Good morning, everyone. And thank you for joining me on this rainy Monday morning in New York. Good morning, everyone. And thank you for joining me on this. Well, gotta turn the phone off. It's very early here in New York. Well, I'm not a morning person. My name is Melanie Little. I'm a recovering lawyer, and I am not a morning person. This is the biggest cup of coffee in the world, and I'm going to drink it. So many of you were interested in catching up on this Take Care of Maya trial that we decided to come back today and watch the opening statements together in this trial. If you have not caught up on the facts of the Take Care of Maya trial, I linked the video from last night's show down below, the description of this show, so that you can go back and catch up on that. Now, did everybody do their homework and watch the documentary if they haven't already seen it? If you have seen the documentary, put a 1 in the chat. If you have not seen the documentary and you're not familiar with this case, put a 2 in the chat. Just curious. Yes, Sarah. I know. Oregon really played a really good game. Yes. Very sadly, the Buffs were creamed. Luckily, it wasn't a complete shutout. At some point, if your kids have ever played t-ball or Little League Baseball, they used to have, I don't even know if they still have it, but they used to call it the mercy rule, where if one team would score a certain number of runs in an inning, I forget if it was 5 or 7, they would call the inning and they would let the other team come up to bat. You know, it's part of the everybody gets a trophy generation. But no mercy rule in college football, and Coach Prime is amazing, but I think the team's going to have to step up their game a little bit because Pac-12 is not an easy conference to play in. Good morning. Good morning, Miss Donna Marie. Wendy. Hello, Wendy. I see my mom in the chat. Hi, Mama. Good morning. Yes, Scott. that could be true. I love Coach Prime. I love him. I do. He's so inspirational. And that was a little bit of a, he drives a Lamborghini, apparently. I think it's a Lamborghini. And I think he got a ticket recently because I follow all the Buffs Instagram. And there's New York Buffs and there's the CU Buffs. Okay, a lot of people have not seen the documentary, which is interesting. I watched Sarah saw it twice. Sarah, I saw your note about leaving me a long comment. I did not see the comment. I will go back and look for it. No, I did not see it. Is it a comment that's pinned to the comments in the video? Or was it in the chat? I didn't see it. I got a lot of comments and I usually go through them. And that's why I'm not a morning person, because I usually stay up until about 3 o'clock in the morning, just reading comments, doing research. And anybody who has a lot of kids knows that once your kids finally go to sleep, it's the only time you really have to yourself. So I stay up late. My kids are also off today. Today is Yom Kippur for anyone who is fasting. I hope you have an easy fast. If you are fasting, maybe you're not allowed to watch this. I don't know. I'm not sure what the rules are. But I hope you have an easy fast. That said, let's dive into this. I just wanted to read you one comment so that you could get a little more insight into CRPS and what it's like and what it can do to a family. And if you recall, this is the disease that Maya is diagnosed with, and the disease that her mother fought so hard to try and get her care and treatment for when she was had her parental rights stripped in Florida and had her daughter Maya placed into state custody. And that's really the crux of this case. But there was one comment that I had from a viewer whose daughter was diagnosed with CRPS, and it was so thoughtfully written, and it was so compelling that I wanted to read it to you. But unfortunately, because I'm trying to close my tabs a little more often, I may not be able to find it. Just give me 2 seconds. There are a lot of comments here, and it is not going to pop up immediately, so talk amongst yourselves for 2 seconds. I heard from at least 3 or 4 viewers who have been diagnosed with CRPS, which used to be known as RSD, complex regional pain syndrome. And I would like, if anybody is diagnosed with CRPS, I would like you to reach out to me so that perhaps you can come on another show to explain to the viewers the difficulty in diagnosis, how debilitating this disease really is. And I hope that they're going to go through this during the trial, because I think there's no way that a jury can decide this case without knowing the full effects of CRPS and how it is so often misdiagnosed and how debilitating it can be. And there are a lot of strong opinions on both sides of this case. And I think that if we watch this trial together, we are going to get a better grip on what is at play here. Okay, here it is. And this is from Tracy. And I hope she doesn't mind me reading her comment, because I just think everyone should hear this. She says, my heart breaks and has some understanding for Maya and her family. My daughter was diagnosed with CRPS when she was 8 years old. Her body turned on her after a netball injury, and that is common. Some people are diagnosed with CRPS after some or other sort of traumatic injury. The pain of this condition and how it affects the nervous system, bowel, bladder, heart, gut, and even swallowing reflex is a nightmare. I had to learn how to catheterize my daughter as her bowel and bladder shut down. The pain would drop her blood pressure, which caused seizures. While it started in her legs, like Maya, it spread to full body. This was hell, and my daughter got to the point where she attempted at 18 years old, and thankfully is here today with me. On YouTube, you can't say certain words. Let's just say she tried to, I think, unalive herself when she was 18. And this is also known as the unaliving disease, if you will, because often the pain is so debilitating that people just can't live with it. And especially because it's diagnosed in mostly young women and girls that, I mean, her daughter was suffering with this for 10 years, being in pain 24 hours a day. Anyone who has an adult, who is an adult who has suffered with chronic pain, knows how depressing and debilitating it can be. As her mother, we had to fight for her health care at times while we lived in the hospital. However, we are lucky living in New Zealand. You always meet some new doctor that doesn't know much about CRPS, and as parents, you are informing them of your children's health and medications. Maya would have had some tolerance to any pain medications by that point. It was so very wrong. I broke watching this documentary. Thank you for covering this and for giving awareness. And really, the kindness that you show to each other in my comments is so touching. And this is really such a nice, amazing community that we are building here. And, you know, before I started doing this, I guest hosted, as you know, on Police Off the Cuff and Duty Wrong, but I wasn't really a YouTube watcher. I know that there are people that watch YouTube all day long, and now I am often one of those people because I find so many interesting things to watch and so many different points of view and so many conspiracy theories. And I like to watch live concerts and live music and clips that people post that from concerts that they were at and songs that I want to hear. So, you know, for many years, I only watched it for the music, and now I start watching it for the content. And there's a lot of channels out there that are very cold-hearted. I watched, because now that I'm watching a lot of stuff about Maya and just the news clips, I did watch another podcaster or YouTuber do a show, and I'm not even going to name it because I don't even want to. You can probably find it. It's out there. It was a man podcaster, and he had a woman who was a guest on the show, and they tore apart this documentary with such callous disregard for anyone who may have CRPS, anyone who may suffer with a child with a chronic illness, anyone who may have their parental rights stripped away. I was horrified. And a little deeper dive into who the guest was. It was a female guest. She apparently is a child abuse reporter, or she works in some part of the system. Oh, Sarah, thank you so much for the super chat. You have had full body CRPS for 16 years. Okay. I want to do another show about this. I don't think we're going to have time to get into this today, Sarah, but if you're willing to come on the show and talk, even with your camera off, I think that a lot of people would be really interested to know what that's like. And as we discussed yesterday, and Sarah, maybe you'll confirm this, that CRPS is one of those diseases that can go in and out of remission, where one day or 1 month you can feel okay, and then something will happen or nothing will happen, or just because the passage of time, you will go back into full-on 24/7 pain. And it's really debilitating, and it can be very depressing, and it can put people into thoughts of ending their life. And unless you have a good pain management doctor, a lot of people are going to tell you originally before you're diagnosed that it's all in your head and it's psychosomatic. And listen, it wasn't that long ago that people didn't take, and doctors didn't take, postpartum depression seriously. And they thought it was just something that women were making up. So listen, 87% of my audience is women, and I'm here for you, and I see you, and I hear you. And these are things that need to be discussed, and we're going to talk about them. So let's do it. Okay. So what I want to do today is go through the opening statements with you. I'm going to give a little disclaimer at the, oh, thank you, Sarah, for your second super chat. Yes, I got the first one, and here's the second one. And thank you so much. I would like to talk to you. One of my mods will give you my email, and you can reach out to me, and we can chat. Anybody who's watched any Law and Order, let's say, for the past 25 years, or any court television show, and has never served on jury before, is going to be a little bit surprised that not every attorney or trial attorney is as charismatic as the lawyers you see on TV, as interesting, and as listener friendly, let's say. And a lot of you who have watched these opening statements have said to me, let's please speed them up because they're very slow. And I agree with you. So while I'm going to start off at regular speed, I'm then going to put it on to 1.5 speed. And if you think that is too fast, let me know. But it's a little bit slow in the beginning. So let's just dive right into this, because we have some stuff to catch up on before court starts again tomorrow. And then I want to live stream it so that we can discuss it together. This is my channel. I do stop the feed to comment on the feed because that's what I do. I'm a legal analyst. I come to you with 30 years experience as a litigator in New York State and federal courts. And it's my job here, and not my job, but it's what I want to do. I want to explain this to you. I want to explain why they're doing what they're doing, why they're saying what they're saying, what I think is effective, what I think may not be defective, what I think may be defective, what I think may not be effective. And you're going to see that for yourself. If you have ever been on a jury, you know what this is like. If you have not, this may be eye-opening for you. Deb, I agree with you. I think they should have kept the openings shorter. And that is also, my opinion. Look, my opinion is, and I'll just tell you, oh, is Robbie here? Hey, Robbie. Robbie's from Australia. And so, with the time change and all, hi, Robbie. It's good to see you. I haven't seen you in a while. It must be difficult, but I think it's, I don't know what time it is in Australia. I think it's not tomorrow yet, right? It's Monday in New York. I don't know if it's Tuesday yet in Australia. But let's get into this. In a civil trial, the plaintiff starts with the opening statement first. The plaintiff is the person who brings the lawsuit. In this case, it is the Kowalski family. It is Maya, her father, and her brother who are the plaintiffs in this case. And the plaintiff's attorney goes first. Civil trials have 6 jurors in the box, not 12. So that is another difference. The other difference is the standard of proof in a civil trial. In a criminal trial, as you know, because we normally handle criminal trials together, we watch criminal trials, they have to prove their case by a beyond a shadow of a doubt, beyond a reasonable doubt. There has to be, all the jurors have to agree. It has to be, here's the scales of justice. It's got to be like this in a criminal trial. In a civil trial, it just has to be by a preponderance of the evidence, which is really just tipping the scales to one side. So completely different standard of proof, completely different jury makeup. There's only 6 people on the jury. I have been called for jury many times. I never get picked because most of the time I know the lawyers that are trying the case and they're like, okay, Melanie, bye. Or they find out that I was a plaintiff's attorney and they're like, all right, goodbye. You can't be fair. So, and even in criminal trials, they don't call me. I don't know why, but I always thought it was fascinating and I always wanted to serve on a jury because I don't think there would be anything more interesting than being a fly on the wall in a jury room. So they're not going to call me, but they may call you. So let's check this out. This is the plaintiff's opening statement. We're going to start it at regular speed. Let me know that you can hear it.
Plaintiffs will prove that from July 7th, 2015 through January 13th, 20.
Okay. Can you hear it? You may have to turn up your volume when he talks, but I'm going to stop it right away because I don't like to bash other lawyers, so I'm not going to bash other lawyers. I'm just going to tell you what I would do. And what is typically done, at least here in New York. Before you start talking to the jury and telling them what you think you're going to prove. And remember, opening statements are not evidence. Nothing this lawyer says during his opening statement is evidence. The purpose of an opening statement, if I have any law school students, that would be really interesting too, because while I'm not a professor, maybe I should be a torts professor. Maybe that could be another, 4th career for me. They're going to tell you in their opening statement what they intend to prove. The evidence is going to show this. The evidence is going to show that. You are going to hear from this witness, and this witness is going to tell you this. And Dr. So-and-so is going to testify, and he's going to tell you this. And you're going to see the medical records, and you're going to see the video deposition testimony of so-and-so. And you are going to see the medical records, and I'm going to show you this, that, and the other. But when he first gets up to start his opening statement, what I would ordinarily say is, and this is a weird thing that lawyers say when they get up to address the court. May it please the court. Your Honor, defense counsel, ladies and gentlemen of the jury, my name is Melanie Little. I represent the plaintiffs in this case. To my right is Maya Kowalski. She is the plaintiff. And I would introduce my clients to the jury. I would address everyone. He did not do that. He did not do that. He just got up. He started talking. He didn't introduce himself. And I just, it's a little bit odd to me. So I just wanted to point that out to you. Let me just start that, rewind that a little bit.
Missed a diagnosis of complex regional pain syndrome on 7 different.
Where's my my tech people? I have this toolbar at the bottom of my second screen, so it's kind of like interfering with my ability to reach the controls. So I don't know how to get rid of it. Hudson, are you here? Hudson. Oh, this is what happens on live TV, you guys. All right. Starting over, remember what I just said, and let me know if this, if this would turn you off as a juror, because as I often say, sometimes cases are won based on the attorney that the jury likes better. And it's a terrible thing to say, but it's sort of like, I like this guy better, so I believe him more than I believe the other guy. And this has a lot to do with credibility. This is all about credibility. So here we go. This is the judge. His name escapes me at the moment, but here's the judge.
Okay, so we are all good to go for the next 90 minutes. Mr. Anderson, you have the floor, sir.
There's Maya in the front row. She's 17 now.
Plaintiffs will prove that from July 7th, 2015 through January 13th, 2017, Johns Hopkins missed a diagnosis of complex regional pain syndrome on 7 different occasions when Maya was in for their care. We will prove that they misdiagnosed Maya's symptoms from October 7th through the end of the year, wrongfully accusing Beata and Jack Kowalski of child abuse, and alleging and attempting to show that Maya had a mental disorder, that she was crazy. She was making it up. We'll prove that they realized their error pretty quickly. And instead of apologizing, saying we're sorry.
Okay, here's another thing that I find really annoying and disruptive is when the defense attorney objects, or either attorney objects during the other attorney's opening statement. There's really no place for an objection here. He hasn't really said anything yet. He may be object because he wants to throw off his flow, which I find to be, I mean, listen, the guy's 30 seconds into his opening, and this guy feels like he needs to make an objection to throw him off. I don't like it. I think it's in poor taste. And that's my opinion, and I'm sticking to it. It is not sped up yet, but since you've got a feeling for his cadence, I'm going to put it on 1.5 because he does speak slow. You know what? Maybe it would be good to put the subtitles on too, in case you can't hear it. Understand also that the subtitles are not always correct. Okay. So here we go. So now they're going to have their little sidebar about whatever this objection is about. It may be because the judge has already ruled that he's not allowed to say something or talk about something. That's Maya's father sitting behind her in the gray suit.
Continue, Mr. Anderson.
Upon realizing their error, for the next 3.5 months, they took every step in the world to attempt to force the Kowalskis to agree with the wrongful diagnosis. Maya Kowalski was falsely imprisoned and battered. She was denied communication with her family. She was denied communication with the outside. She was told that her mother was crazy. She was told by social workers that one in particular, she would be her mother. She was put into a room and left for 42 hours with a commode just out of reach because the hospital wanted to prove that she could actually get up and walk. So they wanted her on video, this is a surveillance room, to get out of bed and then go over to the commode when nobody was watching. Instead, she defecated on herself. For 42 hours, she was kept in that room, denied access to anyone or anything, under the false assertion that it was an EEG exam. Maya was repeatedly battered by nurses and social workers who were trying to prove that she did not have CRPS. Things were done such as coming in and patting her on her leg. They were hugging her against her will, took her down to the chapel, sat her on the lap of one named Kathy Beatty, who told her that she would be her mother. Her mother was, crazy, and that she needed a mother, and that social worker would be there. Maya was kept from her family and friends. She was denied access to her priest. She had what they call religious artifacts, such as holy water, her prayer book, her rosaries taken from her on the belief that her mother was controlling her over religion. She was denied access to counsel, at least insofar as having the ability to actually meet with her attorney without people listening in at the door. All of her phone calls were monitored. Her iPad, computer were taken away because she was told she might be, this is a 10-year-old, cruising internet sex sites. Maya was denied the comforts of her friends and her family throughout her stay there. On another occasion, again, to try to show that Maya did not have rather significant symptoms of CRPS, which you'll see are these small little red, angry lesions that appear on different parts of the body, underneath the arm, along the arms. sometimes on the legs, sometimes on the back. And you'll see photos here in a moment. But in order to prove that she didn't have one, she was systematically stripped and photographed against her will and without any authorization from anyone, least of all her parents. They continue to accuse the Kowalskis, Jack and Beata, of being child abusers, even after the evidence, we believe you'll conclude, was overwhelming that she had CRPS. In fact, we will see whether at some point they even admit she has CRPS in this case. Yet they still, throughout this period of time, continue to accuse Beata of child abuse and Jack of child abuse, something called Munchausen by proxy, which means that you're intentionally trying to keep your child ill. It's usually a circumstance with a very small child where a mother will be like putting something in an IV or things like that. And Maya, at this time, was 10 years old. There's no evidence whatsoever of Munchausen by proxy. By January 13th, when Maya was finally left out of the hospital, unsurprisingly, this family was a wreck. Maya was not let out of the hospital even after her mother committed suicide on January 7th of 2017. Now, the story with Beata Kowalski is a complex one, and I'll tell you about it in a moment, but we will prove that the continued...
Her name is Beata, Beata. They are spelling it wrong in the subtitles. I just wanted to tell you that her name is Beata, Beata. She came over from communist Poland when she was 16 years old.
Allegations that she was crazy and that she was trying to harm her own children, both Kyle and Maya. And the knowledge of the systematic abuse of her child in the hospital caused her, at the end, to lose completely and utterly her ability to control the maternal instinct, and that outweighed the survival instinct. In the process, they caused Beata Kowalski her life, denied Jack a loving wife, denied both Kyle and Maya a loving, caring, and amazing mother. They caused just terrific and permanent psychological injury, as one may expect, a permanent aggravation, and we'll explain the medicine behind that, of the CRPS. Now, the CRPS didn't start with Johns Hopkins. It started about 3 or 4 days before Johns Hopkins. But the evidence...
I want to point out to you the reason why we are seeing a lot of objections to cameras in the courtroom in other cases. And this is a civil trial. Nobody's going to go to jail at the end of this case. And this is Court TV's coverage, and I thank them for covering this live. But this is part of the problem. And this is part of the problem that we've seen in Kohberger during the motions hearings, where they're focusing in on him directly. They're zooming in on him directly. And this is heartbreaking to me to watch Maya in tears and to see how this is affecting her. This is something that the jury is watching. This is something that we are watching at home. And this is something that could influence media coverage of this trial. And imagine if you're facing the death penalty and the jury is zooming in on you. The camera is zooming in on you, and everyone in the public eye is scrutinizing every single move that you make. This can be both good and bad. And I just want you to think about that as we watch this trial being televised in Florida.
Evidence will show that something that could have been a controllable, manageable disease was aggravated to the point where throughout periods in her life, she will be incapacitated. And through all of it, she and her brother and her father will have post-traumatic issues and problems that will, frankly, we'll get that into that in a moment. We've asked in this case for you to consider not only compensatory damages to try to make them whole for these terrible things that have happened to them, but also punitive damages to deter them, to punish them, and to deter this type of behavior in the future. So some of the evidence here will be directed towards that. So that's the overview of what we're trying to do. Now, how are we going to do it? First, you understand that we have really 4 plaintiffs here. We have Maya Kowalski right here. We have Kyle Kowalski, and we have Jack Kowalski. And Jack's also the parent and guardian of both of them, right? So the claims go through him. And then he has independent actions himself. And he's also appearing for the estate of his deceased wife, Beata. And each of them have causes of action, some of them combined. Now, this historic case has been going on. It was filed in October 2018. I tell you this because the key facts in the case began several years before. But through the course of time, we've taken an immense number of depositions. We have found audio tapes, videotapes, surveillance tapes, a lot of evidence for you to review towards proving these allegations. The court claims, again, are medical malpractice, which is that the defendants failed to meet the standard of care, and we will prove that through expert witnesses, that they failed to identify CRPS, which is also known, by the way, as RSD, it's the older name, reflex sympathetic dystrophy, now known as CRPS. Okay, they failed to identify it at first, and then they misdiagnosed it, and then once misdiagnosing it and realizing they misdiagnosed it, the evidence will prove they went about a system to try to get the Kowalskis to admit they were right. Battery, I talked about. False imprisonment of Maya on multiple occasions. Intentional infliction of emotional distress is where you do things so outrageous that they cause damage and injury to a person. In this case, a suicide. In this case, traumatic disorders, depression, a multitude of emotional problems and issues. We've alleged fraud in that they intentionally deceived or attempted to deceive in the proof of the matter. We also alleged fraud in that they billed $536,000 for the treatment of CRPS, and yet never treated her for CRPS, and took multiple positions, especially to them, especially to Maya, that she did not have CRPS. Yet they billed over $500,000 to the healthcare provider and the Kowalskis for the treatment of it.
In my opinion, that's going to be a big problem. That's going to be a big problem that they're going to have to overcome. They can't use that as a shield and a sword. They can't say, we thought Beata was making this up about the CRPS, and that's why we reported them to DCF, and that's why eventually their parental rights were stripped and Maya was put into state custody. They can't say, we thought she did not have CRPS and her mom was making it up and had Munchausen by proxy, and then also be billing at over $536,000 for CRPS treatment. That, in my opinion, is going to be a big problem for the defense. They're going to have to explain it, and the explanation is going to have to be reasonable to the jury. And there, at any sort of, we didn't know, the billing department did it wrong. I don't think that's going to fly with the jury, but you can let me know what you would think if you were sitting on a jury listening to that, just based on strictly what he just said and whether they can prove that or not.
Beata Kowalski was born in 1973 in communist Poland. You may recall that the Berlin Wall came down in 1988, and in 1990, within a couple of years, she was able to escape Poland at the age of 17 and come to the United States. She also had a couple of relatives here already. So she made it over, stayed with relatives in Chicago, and got her AA in nursing, and then her BS in nursing, and then added to it 2 or 3 other specializations. And then eventually, and we'll go to this in a moment, ended up an infusion nurse. Jack Kowalski was born in 1961. At the time all this went down, so Maya, Beata would have been 44 and would have been 50 today. Jack is 62 at this point. Jack was born and raised in Chicago. He was a firefighter and paramedic for over 28 years, rose to deputy chief, one of the Chicago fire departments. He donated time during the post 9/11 recovery to help. He also worked during Hurricane Katrina during the recovery effort. And we'll have some video, I think, about several saves Jack made, one in rather dramatic of a wall collapsing right after he got some people out of the building. For 9/11, he designed a license plate for 9/11 firefighters, the loss, that's, I think, still in use. And he insists on distilling what he further insists on calling wine, which you will not have to try through the course of this case. That was a joke. Well, I'm sorry. So Jack and Beata met in Chicago, and they were married on a cruise in Jamaica in 2004 with friends. Beata became stepmother to Jack's daughter Corinne by prior marriage. They were married, like I said, in 2004. They got along tremendously. There was a lot of mutual interest, one of them scuba diving. Jack was, as we say, a firefighter. Beata was a well-trained nurse working for Loyola University Medical Center in the cardiac catheter lab. Maya was born in 2005. Beata began working for CVS Coram as an in-home infusion nurse, which gave her a little more flexibility in terms of raising a family. And then Kyle was born in 2007. Interesting story there. Kyle was born with thrombocytopenia, which is low blood platelets. And because they needed blood, Beata's blood specifically, but because she had just had a child, she could not give the blood. Beata got up, checked herself out, went to a hospital down the street, gave the blood, collected the blood, came back to the hospital, checked herself back in, and gave the low platelet combating blood to her baby son. The couple moved to Florida in 2014. They already had some family down here. One of Jack's brothers lived here, lived near them. And Jack was able to retire after, I think, 25 years in the fire department And Beata was able to transfer positions down to CVS Coram, and she developed and had wonderful patients throughout the area here. Jack started applying to become a FEMA representative using his experience as a firefighter. That plan, as we'll see, was interrupted by what happened here. Maya, growing up a typical healthy kid, she had some asthma and allergies, as a lot of children do, but nothing that wasn't controlled with the usual. She enjoyed ballet, gymnastics, figure skating with her mom. It's a very big thing in Poland, figure skating. And so Beata spent a lot of time with Maya towards that. And then Maya and Kyle enjoyed fishing in the backyard. Now, Kyle has majored in being skinny for most of his life, although we're finally seeing him put on a little bit of weight, loves fishing. And the new house in Florida they had over in Stonewalk, is that right? Has a pond out back, which is very handy. Now, on July 3rd, 2015, and this is a photo of the July 4th party, Maya started to feel a little bad. She apparently twisted her ankle in the gymnastics accident, or just from doing gymnastics, I guess. And then on the 4th, during all the festivities, Maya simply collapsed on the floor of the kitchen. And I think you'll hear Uncle Bob, her uncle, say she made a noise that no human child should make. And almost immediately had extraordinary pain, which developed over the course of the next 3 or 4 days to the point where it was extremely difficult for her to even walk. This was completely mysterious to everyone. She also had extremely rough coughing fits, which we'll have some, I know we'll have audio of, may have some video of too, so you can see where these came from. These were not, these are from deep within. She was taken to the ER, and then the initial diagnosis was allergic reaction, reactive airway disease. There were multiple theories, but Maya was not getting better. And on July 6th, there was her first inpatient admission to Johns Hopkins. Now, at this point, Maya could barely walk. And she was brought in, testing done. Of course, the parents and her brother are going nuts because they cannot figure out what's going on with her. And she is complaining of being in extreme pain. And so Beata, the nurse, gave a full history of everything she knew to that point, which really wasn't much because it had only been a few days. Johns Hopkins really didn't have much of a diagnosis at that point, although they thought maybe some of the steroids that Maya took from her asthma might have been, causing some reaction. So her first consult with Suzanne Jackman from Johns Hopkins notes low cortisol level, muscle pain, and muscle weakness. Says the pain and weakness may be steroid-induced myopathy. And by this point, Maya, by July 12th, was discharged in a wheelchair. So she came into Johns Hopkins the first time, walking with difficulty, left in a wheelchair. And the diagnoses at that point were secondary to steroid use, generalized muscle weakness, habit, cough. Steroid myopathy is interesting in this case because I think one of the issues may be about the amount of ketamine it all eventually took to control Maya's pain. And something I think you're going to find is that steroids that she takes for her asthma actually have a component that breaks down ketamine pretty readily. We'll get into that a little further on.
Okay, so that's interesting. That the steroids that she takes for her asthma may break down ketamine rapidly, which means that she would need more of the medication to control her pain. And if they can prove that by medical testimony, it might give a little more insight as to why her doses of ketamine were so high and necessarily high to control her pain. We'll see if they can prove that. But you can just see that based on what he's telling us in this opening statement, we're learning more about the case than those of us who watched the documentary. This is a bit of a deeper dive into what they intend to prove. And in this case, which is a little bit unusual, the jury is allowed to keep notes. So they have notepads. They're allowed to take notes. I can see both sides of that. I can see jurors. I sometimes take notes and I go back to look at my notes and my notes are completely wrong from what I remember, or I interpret them wrong, which could be an issue. But in this case, the judge is allowing the jury to take notes. And it's a complicated medical malpractice case, so I can understand that. And I think it's a good thing. So take notes if you want.
Have some experts talking about it.
So that we can see if they actually do prove what he says they're going to prove.
And Maya, like every victim of CRPS, had good days and bad days, but her legs continued to wither. The second admission was July 17th through the 20th, an inpatient admission, again, to Johns Hopkins. There's a history and a physical, presents due to even more increased pain, now moving from her legs to her arms, her back, her stomach, her neck, and head. The differential diagnosis, myopathy, myositis, and now we start in with psychological pain conversion. because they cannot figure out why this child has this degree of pain. In other words, no clue at this point. So as part of the treatment, they suggest that Maya be taken somewhere else, TGH, Tampa General Hospital, for therapy. They thought maybe physical therapy would help the child. And as part of that transfer process, they sent Maya's history and physical notes to TGH, and then had a phone call informing them that they thought this might be conversion disorder, this might be mental. So the first time any of these other doctors heard anything about Maya Kowalski, it was with an initial possible diagnosis that it was all in her head. The child couldn't walk, and certain symptoms were coming to the forefront by this point. Now because Johns Hopkins couldn't figure out what the heck was happening, Maya was taken by Jack and Beata back up to Lurie's Children's Hospital in Chicago. Now, this is her former home. It was a familiar place. Lurie's had treated Maya for this asthma previously. They thought, well, let's take him back and get a second opinion. And so Johns Hopkins was aware that patients were going to seek a second opinion and contacted and talked to them about their theories. The doctors in Chicago couldn't figure out what was going on either. So Jack and Beata proceeded with Johns Hopkins' recommendation to take him to Tampa General. Again, the doctors in Chicago thought, well, it could be steroid myopathy, it could be generalized muscle weakness, or maybe it's all in her head, but nobody made a diagnosis of that. She went to Tampa General Hospital, and TGH, as I said, already had Johns Hopkins records. Now keep this in mind. Facts will show they already had the records. They already talked to them about what Johns Hopkins thought. All right, so Maya had inpatient comprehensive pediatric rehab and physical therapy and occupational therapy for the steroid myopathy. Now, the reason this is important is that there are certain treatments that you get for CRPS before you start ramping up on some of the medicines that are used. So you want to see if the most basic types of therapies can bring somebody around to lower it to the point where it's livable. CRPS never goes away. It is a permanent disease. It's merely controlled.
Okay, so this is important too, because I see a lot of people in the chat, and I saw a lot of people in the chat last night talking about the fact that they think, in their opinion, maybe it was medical child abuse for the mother to be giving her such high doses of ketamine, and that it was experimental, and that it was so dangerous, and that, but it's important to see, and he's going to show that they did try a lot of other things first. So they did try a lot of other less potent treatments, physical therapy, other steroidal treatments. They tried a lot of other things before resorting to ketamine. And I think that's going to be an important piece of this medical component for the jury to understand. That it wasn't, they just didn't go put her in a ketamine coma right away. They tried everything.
But before you graduate on to more advanced treatments, you want to go through the basics. And fortunately, they had the idea of trying PT and OT, but they did not spot that it was CRPS either. They still went with Johns Hopkins theory, that it was steroid myopathy and that maybe there might be some psychological overlay. Again, they missed it. She was evaluated for adrenal insufficiency, inpatient treatment for mood and disorder. She's given Valium and Prozac against 9-year-old girl, 10-year-old girl. Hospital alluded to Maya or Beata falsifying or exaggerating a fall from her bed, and missed several complaints, although they documented several indications of CRPS. However, at that point, she was there for 4 weeks, and as the discharge diagnosis says, history of steroid-induced myopathy, noted as resolved by admission, gait disorder, impaired mobility, ADL, asthma, psychological factor affecting physical condition, conversion disorder versus factitious disorder versus others, anxiety disorder, myalgia. Now, importantly here, you'll see that it says resolved by admission, but we're going to bring in the actual physical therapist that treated her. And you will find throughout this case, the facts will show that there will be a distinct difference between what the actual people who were hands-on treating Maya had to say about how she was doing and whether she's progressive, and what was put down in the medical records.
That's also interesting as well, because that tells us we can't rely on what's in the medical records, because the actual treating physicians are going to come in and say, I didn't say that. What's in the record is not what I observed, and the records were wrong. So that's a real interesting piece of this as well.
The Tampa General Hospital visit was very difficult for her. At this point, she was displaying what is known as dystonia. Dystonia is where the ligaments in it could be anywhere, but in this case, in her ankles and feet, were contracting to the point where her feet were starting to turn in like this. This is a clear indication of CRPS. Tampa General Hospital thought that maybe they should put some boots on her and see if that would correct her feet turning in. And we'll have some video from the physical therapist that shows Maya attempting to walk in those boots, Maya attempting over and over again with things like trying to push her leg and saying, giddy up, Horsey. Again, remember, it's a 9-year-old girl. And demonstrating she was trying as hard as she could to walk. The evidence will show throughout this, Maya did not want to be in a wheelchair. She did not want to be one of the kids that was looking out the window while all the other kids were playing. But Maya kept getting worse, not better. And she was still in pain. And when school starts in 2017, 15, she said she was still in pain throughout her body, and she would moan and scream in time and panic. And she kept getting weaker, weaker, and weaker. Now, Maya was in and out of Johns Hopkins throughout this period of time. Okay? And there was prescriptions for opioids, again, physical therapy, occupational therapy. Nothing was working. No one had any answers. And then a patient of Beata's, one of the infusion nurse patients, said, this may be CRPS. I have a daughter with it, I believe. Why don't you look into seeing this? And there are doctors here in Tampa Bay area that are specialists in this. And so she went to see Dr. Anthony Kirkpatrick at the RSD Foundation, Reflex Sympathetic Dystrophy Foundation. Now, to diagnose complex regional pain syndrome, the Budapest criteria for CRPS gives us certain specific symptoms, diagnostic criteria: persistent burning in the arms, hands, legs, feet, or another part of the body. Check. Multiple medical records will show she had that. Pain can be mild or severe. We have actual audio recordings of Maya moaning. You'll see and hear the child. You can determine whether or not she was in pain. Swelling, sweating, all of those. Dramatic changes in skin color and skin temperature. Testimony is that Maya was constantly too hot or too cold. Now, people get too hot and too cold all the time, but usually they're not 9 or 10-year-old children, to the point where they're either shivering and need a blanket, and then 2 hours later are wondering, why is it so hot in here? That kind of temperature change. And of course, then blurred vision, which is already appearing in the records, dystonia, again, the movement disorder like this, and then a really confusing symptom called aldynia, which is an extreme but often inexplicable sensitivity to touch. It means that on some occasions, you can come up and squeeze Maya's arm or touch her legs and get no reaction at all. And at other times, just the thought of someone coming up to her and putting their hand near her as though they were going to touch her would give off an incredible reaction: screaming, yelling, resistance to anyone even touching her. Reason? That because of the RSD, CRPS, she would feel extraordinary pain as a result. But it doesn't happen all the time, and it doesn't mean that when you don't have it, you're not in pain. One of the experts will testify that this is sort of like, think about it as a cancer patient or someone with an intermittent disease. You may be in remission and be doing fine and look fine to everybody outside. You may be hurting like crazy on the inside, but outside you look pretty good. And then other times you may be curled up in a fetal position and not be able to walk, talk, or move. Also a light sensitivity. Interestingly, the Budapest criteria, which are kind of the accepted criteria for CRPS, are also listed by Johns Hopkins as their diagnostic criteria for CRPS, right? So she goes and sees Anthony Kirkpatrick, Dr. Kirkpatrick, who you'll meet. Now, notice on the photograph, see the feet there turned in? Notice the lack of muscle mass on the legs. She's in a wheelchair, obviously, and that's sort of an attempted smile, but she's got sunglasses on. Now, why is a child wearing sunglasses inside at the doctor's office? Because she has a sensitivity to light caused by the CRPS. So Dr. Kirkpatrick went over the entire full history, list of symptoms and therapies tried. He did objective testing, including pain threshold tests, range of motion tests. We'll actually have videos from before and after, where you can see that before the treatments you eventually had are part of the.
I'm going to stop it here for 1 second. I'm going to say what I always say to you, and that is that when jurors walk into a courtroom, they do not leave their common sense at the door. They come into the jury pool and the jury duty with their experiences, their personal experiences, their common sense, and their own way of looking at things. Everybody comes from a different background. Anybody who's a parent knows, and we talked about this last night, that when your child is in pain, there is nothing that you wouldn't do to take their pain away. You would want to give me the pain. I'll take the pain. I don't want my child to be in pain. It is one of the worst things that a parent can experience is having a child in chronic pain. And especially if she's screaming in pain all night long. Imagine for months and months and months, and her mother is trying everything to get her out of pain. She has such sensitivity to light at 9 years old that she's wearing sunglasses inside, and you can see her condition sitting in the wheelchair. And they're going to try and say that this child is faking. So just keep that in the back of your mind as you look at the pictures of her and you listen to what the attorney is saying, that the evidence is going to show her symptoms were for many months before the admission to Johns Hopkins that is the subject of this lawsuit.
issues in this case. She could barely get her arm up to here. And then you'll see after the therapies that they ultimately complained about that she can put her hand completely over the other side. And the diagnosis was CRPS. Now, Dr. Kirkpatrick did not say, all right, let's just go into some heavy duty pain meds or anything else. Again, he said, let's try some physical therapy and what's known as warm water therapy, which is essentially where you use a very warm pool or bath or something and you do it in there to loosen up the muscles. A little different, but again, physical therapy. He did not recommend out of the box any sort of pain meds. That didn't work. And that's when he introduced them to a revolutionary use of an old drug called ketamine and the ability to break the chain. See, CRPS involves a problem in the pathways between the pain sensors in different parts of the body and the brain. Usually when someone injures themselves, you sprain a finger or something out, it hurts like heck. But over time, right, it starts hurting less and less and less. And pretty soon after a while, you just kind of forget about it. That doesn't happen with CRPS. Because of a problem as yet not understood, which is why we don't have a cure, the pain relay, the circle, the loop here of feedback is getting bigger and bigger and bigger. Until what was once a tiny little fracture or a tiny little sprain or whatever you want to call it, turns into something that is the worst pain known to medical science. I'll talk about that in a moment.
Okay, I think that that was a good way of explaining the pain of CRPS to a jury, because when the medical experts are going to come on the stand, a lot of times they speak in medical lingo and in language that's very hard for a jury to understand. And I think what he did right there was to explain it in a way at the outset that makes it a little easier for the jury to understand that it is the worst pain of any disease, and that it's a pain loop and that it doesn't stop and it keeps repeating and keeps repeating and keeps repeating.
And ketamine, which has been around since the 1950s, is FDA approved. It's used mostly as an anesthetic, and it's not an opioid. It doesn't work like an opioid. But for some reason, not fully understood, it breaks this feedback loop and people start getting better. Not all of them, but a very high percentage get better. So there's actually, I think, do you have the audio on this? So this is one of the initial visits with Dr. Kirkpatrick discussing the use of the ketamine infusions. And I want you to concentrate on what this mom, who's also a nurse, is asking about.
Who in your practice administers the ketamine?
I do.
You do, okay.
And I'm ACLS certified also. I have to take.
As we also discussed last night, Beata was very meticulous about her recording of doctor's visits, phone calls. She recorded everything and she videotaped everything so that she would have a record. Being a nurse, I think she knew that she wanted to be able to refer back to these conversations for her own information, as well as for, seeking other treatment, going to see other doctors so that she can remember what was said. I mean, it's hard when you go to so many doctors to remember what each doctor said. And, when you're so emotionally involved in it, sometimes you just tune out. And if you have a recording of it, it's easier for you to go back and remember and understand what each person said so that you can kind of digest it at a later time, because it can be very distressing while you're sitting in front of the doctor at these visits to hear what they're saying, as many of you, I'm sure, know.
Yeah, you have to be.
Well, pals, you gotta have the
Mhm.
pals and all that stuff. And we have a pediatric code part back there. We have to do all that stuff if we're gonna do.
Good,
children.
absolutely.
Yeah.
That was my next
They're-
question.
they're-
Do you have a pediatric crash card?
No, we have to,
Yeah.
I mean, that's a standard care,
Mhm.
Now, Beata knew all about how to keep her daughter healthy, not this disease, but how to keep her daughter healthy and how to protect her daughter. And notice in there, one of the first things she asked about, is there an ACLS crash cart? Are there all the different equipment that you might need, even during an infusion? Because remember, she's an infusion nurse, in case anything could go wrong. Now, here's the McGill pain scale. This is interesting. I had no idea until I reviewed this. But I'm sorry, this right here, as you can see, this goes over, and this was developed in Australia. It's been around for a long, long time. It's adopted by about every hospital, every medical association. And this describes the different pain levels according to description by patients and every other objective finding that one can make. And you'll see at the top that CRPS is the most painful. It was actually developed at the University of Montreal, Canada by Dr. Lasco, I guess. And most of the clinical trials were, I believe, in Australia. Symptoms of CRPS, we've gone over those. It strikes mostly females in the population between the ages of 7 and 21. It is known for initial symptoms that are inexplicable. However, upon close review and a differential diagnosis to rule out other things and consider neurological disorders, this is one of them. And if you can identify a few of these symptoms, our experts will say CRPS should have been brought into the mix very quickly. That did not happen here. All right, so from
It concerns me just a little bit that he had never heard of the McGill pain scale before. that concerns me just a little bit. If I were him, I probably would not have said that in my opening, because it makes him sound like he's not experienced with these type of med mal cases and misdiagnosis of disease cases. So I probably would not have said that. But what is important to note for the jury and for you listening here at home is that on the McGill pain scale, CRPS is the #1 most painful disease.
October 6th through 8th, she has her first ketamine infusion with Dr. Kirkpatrick, a follow-up, and the first infusion went well and helped to get Maya out of pain, and there was a lot of encouragement over that. He wasn't pushing for more ketamine. He's simply trying to instruct on a conservative approach, warm water therapy. Let's try the ketamine again. They tried it again and again. Got some good relief, but not for very long. Maybe for a week, 10 days, but not what they were looking for, to bring this child back to being a normal kid, right? So at this point, Dr. Kirkpatrick says, well, she might need more and frequent of these infusions. So why don't you go over to Johns Hopkins and visit for a PICC line placement? And so on November 4th, she goes back to Johns Hopkins for a PICC line placement, and the diagnosis over there accepted is CRPS. And so Johns Hopkins itself does PICC line. PICC line is it's basically a tube that's put in so you can do the infusions a lot easier without trying to find a vein. All right. So, and she begins therapy.
Okay. So another important, very important point is that prior to the admission at Johns Hopkins, which is the subject of this lawsuit where they accuse Beata of Munchausen by proxy and faking the CRPS diagnosis, they had inserted a PICC line. They, and in their records in Johns Hopkins, had a diagnosis of CRPS. So during that visit, they didn't suspect Beata of Munchausen and of having a PICC line inserted in her daughter to commit medical child abuse. So it's just an interesting thing to think about if you're sitting on the jury. Well, they inserted this PICC line in her, so they believed she had CRPS. It's in the records. Why did they change their opinion when she came in severe pain months later?
Therapy, because again, everybody wants to find out, is this really anything exaggerated by Maya? Is there a psychological component to this? Let's just make sure. So Maya starts with a therapist by the name of Rebecca Johnson. And I believe you'll hear from Ms. Johnson or Michelle Rogers, who is her partner there, about those. Maya was never determined to have any type of conversion disorder or factitious disorder by any psychiatrist or psychologist, except that as part of CRPS, there can be certain symptoms of conversion, which is, how do you explain this? The feelings of pain become so exaggerated, this allodynia, that the patient is anticipating pain before it actually happens. So she goes and has the therapy, but still nothing is working and nothing is really getting her out of the extreme pain on a long-term basis. So Dr. Kirkpatrick, and you'll hear from Dr. Kirkpatrick here to explain all this. Unfortunately, in the United States, the procedure that had been shown to work the best for intractable CRPS, long-term ketamine infusion under general anesthesia, a medical coma for 3, 4, 5 days, is not performed in the United States. It's performed in Germany. It's performed in Mexico. It had been around since approximately the 1990s. It had essentially 100% rate of safety. That is, no one had ever died from it. And it had a very high rate of success. There is a physician, a University of Texas trained anesthesiologist, Dr. Fernando Cantu, who's going to fly here from Mexico to describe the process. And it involves, again, infusions of ketamine over a very long period of time. The idea being that it causes the brain to reset so that you don't have this feedback loop causing the pain. The first one in late November, 19th through the 23rd, there is a high dose infusion. And what do you know? The lesions begin to heal. And there's a slight less turning out of the feet. And yet the pain was still not where they wanted it. So Maya stayed there. And then on November 19th through the 23rd, she went through another high dose ketamine infusion. Now, during this period of time, other than during the middle of the infusion process, there were absolutely no negative signs from Maya. She had a brief increase in her liver function results, but only we're talking for a matter of hours. And as soon as the ketamine infusion was done, they went right back. And it's important to note that other than at that time, and through all of her ketamine treatments, Maya's liver functions, which is the thing you look at if you've got a medication like this and you want to see, is it hurting somebody? You look at the liver functions, and her liver functions have stayed normal throughout. And you'll see the medical records to show that. All right. So then a miracle. By December 28th, Maya's lesions are noticeably less. Her feet are starting to not be as turned out. In fact, by the end of January, and we'll show you the films, she's actually able to get back in the pool. You can see a picture of her here. in, I believe, late January. And this is her. You'll notice the feet looking better. If he's on Kyle's shoulders there, you'll notice a real smile coming up. She's able to do her warm water therapy, but she still is having some pain. The idea here was to get this kid out of the wheelchair, right? They wanted to get her out of the wheelchair. And to get her out of the wheelchair, they really needed to get the feet totally back and needed to get the pain levels back so it wasn't so painful when she walked, so she could build up her legs. That was the idea. So they go back to Johns Hopkins, okay? All right. Central port means there's an operation, and there's the note. Placement implanted central venous port. That's a tube under her arm to allow her to continue high-level fusions, not like Mexico, but outpatient procedures. And she has a number of them through the course of the next 9 months. Through the course of this, and with a doctor named Dr. Hannah, who Dr. Kirkpatrick recommended, Dr. Cantu recommended, because frankly, ketamine is incredibly expensive and it's not covered by health insurance. So Dr. Hannah was set up to do these on a regular basis. Oh, yeah. Oh, I better get going. Okay, so Maya goes back to Johns Hopkins, and Dr. Anthony Kreisman, who had seen her before, a long-term ketamine infusion, quote, ketamine coma, and they commented on how withdrawn and how much pain she's in. Listen to what he says on May 11th, after about 30 of these infusions and the long-term infusion. She is a completely different child from when last examined. By that, I mean she is not in any pain. She is not moaning. She is smiling and interactive. She is very engaged. She moves spontaneously in her wheelchair without incurring pain. Through the course of that summer, because the ketamine is so expensive, they tried 2 other therapies. One's known as hyperbaric. You can see it right here, extreme high oxygen content, which has been known to help some CRPS patients. She also tries the IVIG treatment to increase her immune system, because it's believed that CRPS can be, the immune system may be part of CRPS. And by the end of the summer, she is almost back on her feet. This is in 2016, around August of 2016. Maya is almost back on her feet. We have video of her actually using that as kind of a jungle gym to try to strengthen up her arms and her legs. Everyone is very excited. Everybody is looking forward to Maya getting on her feet. And then she has what they hope to be a minor relapse. It turns into a fairly major relapse. And she goes back and has larger ketamine doses with Dr. Hannah on October 5 and 6. And she has some gastrointestinal problems and a lot of pain in the midsection. There are stories that you'll hear about her screaming at night. She could not take the pain in her stomach anymore. At one point, the screaming was so intense that the family got walkie-talkie, so the family could stay all the way over on this side of the house and Maya over here, because no one could sleep. So we communicated by walkie-talkie. All right, so they decided on the 7th, October 7th, a key date, to take her to Johns Hopkins ER. Now, the reason was that we had Hurricane Matthew tracking up. If you've been in Florida long enough, the hurricanes start to blur together. I believe it's Hurricane Matthew tracking up the eastern seaboard here, getting winds like, I don't know, 35 to 50 miles an hour. To people from Florida, it's like, wake us up when it's a Cat 4. And but to, the Kowalskis were from Chicago and had never experienced this before. They had visions of like a movie Twister going around their head. And so all of the ERs and everything were closed. They took her up to St. Pete to the ER. And Maya is seen by 5 different doctors and groups of nurses and social workers from the ER. And she comes in about 8:46 in the morning, and she's crying and screaming, and she's in a fetal position, clutching her stomach, and she is just out of her mind. And the ER doctors there start to react rather negatively to this. Beata comes in approximately 2 to 3 hours later, and once again goes through the history, which Jack has been trying to relate, of all of the different visits to Johns Hopkins and all the different treatments and how everything has failed. And the only thing that has worked has been the long-term ketamine infusions. And we can try this. Can we try that? Can we try a pump? What can we do to get our daughter out of pain? For some reason, the doctors there either review all the past records and the some 7 to 8 to 9 prior visits, and the fact that she's had surgery there to have a port implanted to help her with the ketamine infusion. But for some reason, they decide that that isn't it at all. She really doesn't have CRPS, that the mom must be making all of this up, that this is, as a nurse who we think is the one who actually made this diagnosis, Munchausen by proxy, textbook Munchausen by proxy. Imagine this is an ER, the child's back there, the parents pulling their hair out, trying to explain to the hospital, this is what Jack will testify to, Beata's trying to explain to them in an ER where they've been about 5 times before, exactly all the history that's going back, that's already in their records, including records from the other hospital. Everything's there. For some reason, the doctors, nurses, and social workers ignore all of that and decide this is not CRPS, that this is the child is making it up and the parents are making it up, and then this must be child abuse by the parents. Now, the court has told you that there's pretty much a hair trigger on suspicions, and so they make the call, and that's not part of this case. You're supposed to make the call. Slightest different suspicion, you're supposed to make the call. So that's not a bad thing, whether it was right or not at that moment. The case is about what happens after that and the failure to diagnose previously so that none has ever happened. Maya, they try to take Maya home after the first night. They're told that they need to observe the child overnight. Fine. But by the second day, Maya is still in pain. They do knock her out with a lot of drugs to get rid of the initial pain. And they give her ketamine. So the next day, she's much calmer. And so then they decide that Maya cannot go home. They decide that taking her home is AMA, against medical advice. And they say, if you try to take your daughter home, we're calling security. So the Kowalskis don't have much choice. They end up leaving. And the next thing they know, they're off for the races on, and Maya is an unbelievable journey up through and including the death of Beata. Now, what you'll notice in the records, again, the records paint a glowing report of Maya. Just how great she's doing, how much she enjoys things. What a great day she's having. She's getting this, she's getting that. The only thing she was getting to do was play the piano. Maya knows how to play the piano. She got to play the piano. She got to draw pictures. Every once in a while, she could send a letter. If she wanted to talk to her mom, it had to be on a supervised call. She could only see her dad and her brother on pre-arranged and monitored situations. If she wanted to see, they hired an attorney, obviously. If she wanted to see her attorney, the nurses would demand that the door stay open. She never had a private moment with an attorney. They're Polish Roman Catholic, which is about as Roman Catholic as you can get, and have a very close relationship with the priest. So the priest went in to see Maya, and he will testify that when he arrived, he was told that he could not see Maya, and that she had had her religious artifacts taken away. We have a photograph of it. And he asked about this, and they said it's because we believe her mom is controlling her through religion. And so he was not allowed to see her that day. And it took a few other attempts. And then finally he was allowed, but he was told no religious procedures. You come say hello, no religious procedures. I told you already about the 42 hours of being placed in a darkened room and told this is a new type of EEG, Maya. We're gonna really figure this out if this is in your mind or not. No, it wasn't. It was the surveillance room. And again, the goal, because these doctors had somehow gotten confused to think that CRPS includes paralysis. Paralysis is not part of CRPS at all. And yet they were trying to prove that Maya could actually get out of bed, that she was faking it, that she was sitting in that wheelchair all the time, just, I don't know what reason, but she was faking all this. That actually, when nobody was watching, Maya was getting up out of that chair and walking around everywhere. So they put the commode just a little bit out of reach, right? Figuring when she thinks nobody's watching, she'd get up and she'd go to the bathroom, go over there. Well, that didn't happen. And you'll see video of Maya having to be carried over to the commode. Of course, her skin started to show the lesions again. Mine started on a dive, badly getting worse. Depressed. The lesions are forming. You'll see them. Yeah, here, now they just may look like scratches here, but you can't see too much of the stuff on the back. What you'll notice through the series of photographs, and thank goodness Dad here took photographs of Maya's lesions, and you'll see those photographs, and I want you to compare them to the medical records, because you'll see on the dermatological reports, you'll see skin normal, and yet you'll have photographs from that day showing lesions. On January 6th, they decided that they needed photographs to prove that Maya really didn't have as many lesions as they said. So they brought someone else in, and we have better pictures. You can see a little bit of Maya's face there. They claim, oh, this didn't bother her at all. There was no authorization from the family, no notification to the family. Maya was screaming bloody murder not to do this because it hurt. They took off her clothes, except for her training bra and her shorts, pulled down her shorts, pulled up her shorts there to take photographs of her. Now, their testimony is, oh, this wasn't bad on her at all. She was fine with it. No, what she's told is, if you don't let us take photographs, you're not going to see your mom. That's what they told her. So they end up taking photographs, and somehow, where are the photographs? We've only got a few. We do have photographs from the father at the time, however. So by this point, it's pretty bad. Let's talk just briefly about Beata. During this period of time, Beata is only allowed to talk to her daughter. Hopefully, we'll be able to play some of the tapes. We'll be able to hear Beata trying to talk to her daughter, but they put certain things off limits, like, how are you doing? How is your treatment? How is your medication? Things like that. No, you can't talk about that. Not allowed to talk about that. They're the most mundane things you can imagine on these cell phone calls. We are allowed to use them. And in those, you'll hear one of the social workers, Kathy Beatty, who was assigned Maya. Now, she was a social worker from 1-4, but wherever Maya went, Kathy Beatty followed. And we have the trail of emails and notes leading from notification to the general counsel through risk management on down to one of the senior doctors, down to Beatty, about doing this stuff, including what you just saw there in the photograph. We'll prove they knew it at the highest levels. Beata is going freaking nuts. The evidence will show. They find out that Beatty's had some disciplinary problems. They find out kind of through the grapevine, how bad things are for Maya. They find out about the lesions. Now her feet are completely turned in. And Maya has become so weak. The CRPS has developed to the point where she can't sit up straight. Okay. Now,
Okay, now this is interesting too because her condition is rapidly deteriorating, and anybody who knows anything about Munchausen by proxy knows that one of the indicators of Munchausen by proxy is that when the child is separated from the parent, the child will improve. Correct? So this is very interesting that she's rapidly deteriorating in her medical condition and her CRPS is worsening, and yet they continue to maintain that her mother has Munchausen by proxy, and they stick to this during the administrative proceedings, the shelter hearings, and all of the proceedings that the family is forced to go through with their attorney to try and regain legal custody back of their daughter because she's now, remember, in state custody, and this goes on for 3 months. And I think he's almost done.
on the evening of January 7th, Beata, they were going to a party. Jack and Kyle were going to a birthday party, I think. And Beata had been not acting herself at all for a number of days. And she didn't want to go to the birthday party. She didn't really want to go anywhere for a long time. The only thing she did was go to work. She was withdrawn. She and Jack had been having screaming fights because Jack did not want her to be so absorbed in this. He was more of the, let's just try to get her out of there, work her out. And Beata was trying everything, legal, social, every possible way to get her child out, and her child was not coming out. And she found out through several sources the condition that Maya was in and what was happening to Maya. And on that evening, once they were out, she decided to take some belts and put them together, go out to the garage, make a noose, put a stand below her feet to be able to reach it. She took an IV of saline solution and put the IV in her arm and left a cell phone with a note that said retribution, retaliation, out. And she left 2 suicide notes, which we'll try to bring before you, telling you about why she did. It took probably about 22 minutes, according to pathologists, to strangle to death. She kicked the stand out from under her.
Again, cameras in the courtroom. Cameras in the courtroom, guys. This part of the opening statement is he's talking about her mother unaliving herself, and instead of focusing on the attorney who's making this statement, they are focusing on Maya's pain, and I am really upset by this, as you can see.
When Jack and Kyle got home, they thought that she was sleeping in another room, which they did a lot, because they weren't getting along, frankly. And so nobody did that. And then Beata's brother was coming in that night. He came in and went to sleep, got up the next morning, walked out into the garage, I guess looking for something. And at first he thought it was a Halloween costume or something. And he looks closer and it's his sister. And he, of course, just completely screams out. Jack comes in, sees his wife with Kyle right behind him. Kyle was, I don't know, we'll ask him how much he was able to see. 911 call made. You'll hear that. And Beata is taken down. We'll have some, we're not going to get gross on them. We're not going to try to upset you too much on the photos, but we will show you some of the photos, right? Now, after that, Jack says, let my daughter go. If Beata is the big reason here, if she's a Munchausen by proxy, why keep Maya? No. It takes another week and a half, and Maya, get it straight. Maya's actually told in the hospital their mom's dead. Johns Hopkins believes it's still in her head, and there's a text that goes around about how Maya's now better off because her mom's dead. Between 2 of the doctors you'll hear testify. Finally, after a lot of effort, Maya gets to go home. Now, I'm not sure if I got the photograph on this, but I'll show you a photograph.
If that doesn't horrify you, that there's text messages going around between the doctors that Maya's better off because her mother is now dead, nothing will. And if he's got those text messages and they're authenticated, going to be a big problem for the defense, in my opinion, because a lot of these cases are fueled by the jurors' emotions and I see a lot of you in the chat that are defending the hospital and their decision to keep this train chugging down the track, that the mother has Munchausen, despite the fact that they had indications to the contrary, and defending the hospital. And I'm going to sit here and I'm going to tell you that the jury is not going to make a rational decision on that. Perhaps they may be fueled by these doctors' text messages saying, oh, she's better off now. Come for me in the comments. Come for me in the comments. I welcome respectful debate.
Photograph, you can see on the ride home, she's got stuffed animals underneath her, and she's slumped over like this because she's so weak she can't keep herself up. Through the course, then. Okay. All right. So the hospital will now come in and tell you just how great their therapies were. We'll show you the records, and they were not doing any therapies with Maya. They were warehousing the child. Maya gets home, and with her parents' care, on one other thing, the hospital doesn't want any more use of ketamine ever again. We'll get into the details of that. So just using the old, regular, and largely ineffective pain meds, this child manages through warm water therapy and being home with support and love about 8 months to get out of the wheelchair. Now, I want you to compare that to the time after they first learned about how to use the ketamine, how fast it took to get her ready to roll, right? Out of pain. This child does it in extreme pain. So she's on crutches here about the spring of August of 2017. And it takes another year until Maya can walk unassisted. She's on crutches. One tough cookie, and we'll talk about just how tough she really is to be able to go through all this. Things go well for another couple of years, but in 2020, she has another bit of bad news about her schooling and has yet another relapse. This time, again, similar to the one in 2016, and similar, it was an emotional issue. The one right before she went into Johns Hopkins, pretty much the same type of symptoms. And she ends up back in the hospital, and she has to be put on a feeding tube because she's in so much pain she can't feed herself. So fortunately, after about a week there, she was able to get well enough to come out and proceed on her way. And again, had to start over in some ways, and was able to rejoin a lot of her life. Without her mother, Jack lost a wife, Kyle lost a mother, and the effects on the family are, well, you'll just have to listen to hear. Okay? So we're asking for damages for the physical injury, the overwhelming pain, not simply from the ketamine alone, but from the aggravation of the ketamine. Let me talk about this. Now, the CRPS started before Johns Hopkins ever got finished, okay? But the evidence from every doctor that's a specialist in it will tell you that it is vitally important during the first episode of CRPS that you properly manage it in order to prevent an aggravation of the disease to the point where it's going to reappear, and you will have longer, more frequent, and more devastating episodes down the road. The ketamine's nickname is the suicide disease. So the law is then that if you take a symptom, an illness or injury, and you aggravate it to the point where that person has a lot more pain, a lot more trouble with it, that unless some doctor can come in and identify the percentages back and forth, they're on the hook for the whole thing. All the ramifications. So now we've got long-term effects, and we're going to give you mortality tables so you'll be able to know how many years out. I'll give you some formulas on how to try to do this. I'm just an advisor. You ultimately will make all the decisions here, right? But I'll try to help with some formulas of how you can calculate those things. It's a difficult job. We talked about this before here, right? All right. So we'll talk about each and every one of these. We'll talk about the physical injuries. We'll talk about, and Jack has, I haven't spent any time on Jack, but we'll get into that again on the testimony. Suffice to say, it's been devastating to not have his wife and the mother of his children. Kyle's lost a mom and the effects on him. So we'll talk about the pain and suffering, the mental anguish that you will carry around. They will carry around from not having a mother and knowing your mother killed herself for you. We'll have inconvenience. Now, Beata was a nurse, so she could take care of herself and she could take care of her family. She's not around. Loss of capacity to enjoy life. There's this thing called alhedonia, which means that you lose the ability to have pleasure out of things that once gave you pleasure. Maya tried figure skating. She won't do that anymore. Maya's not going back to gymnastics. Maya doesn't want to play piano anymore. The family doesn't want to go back to the church. And the family is having an extremely difficult time staying in the house, obviously. There's diminished earning capacity because what happens on your job if every year or two or every 6 months you have this debilitating episode where you can't work and you can't explain how long it's going to be and whether you're going to be able to do anything at home or not. And like I talked about, the aggravation of the pre-existing symptoms and the illness. So then we ask you to consider punitive damages. Our argument is this, that these actions are so completely and utterly it's designed to deter, not only here, but in the future. And it's designed to punish, right? And so your decision there would be predicated on how much money does it take if we got to that point? What alters behavior of companies like that? So that's your job. Is to figure a little bit out about this, a lot about this. And so I was trying to figure out where the defense is going on this. I think it is that from their doctor's point of view, those doctors in the ER and hospitalists' view, Beata was crazy. And they thought she was going to try to hurt her daughter. Then explain why. Mine did not come in with a bruise, a bump, a cut, a scrape, any bad medical tests, no bad blood work. And yet they deduced from their discussions with her over the course of a few hours that it was actually her plan. We will show you that up until this point, periodically through the latter probably 10 years of her life, Beata had periods of anxiety, and she got treated with things like Xanax for that. And she had 2 periods of depression where she had some anti-depression stuff, never long-term and all situational to events in her life. After January of 2016, and her daughter had been through this, she sought counseling and maintained counseling to try to get through what she was going through. We'll have Dr. Tashana Duncan come in. Circumstances about her. She's a PhD psychologist who knew the story and did an intensive amount of research, and she says there was nothing wrong with Beata whatsoever. And not a single psychiatrist or psychologist is going to come in and tell you any different view. And we doubt you're going to hear anything from a psychologist or psychiatrist to say that Beata, that Maya was making any of this up, or that she was suffering from factitious disorder or conversion disorder. We doubt, seriously, you'll hear that. If the defense does come up with something, listen to my cross. They say that the amount of ketamine that the CRPS doctors were using, and the fact of the ketamine, as they call it, the ketamine coma, it's kind of, in this case, that's their boogeyman, is the ketamine coma. You'll hear one of the doctors say that that's the reason why they should be able to take Maya away from the parents, because they didn't think that that was that was met the Johns Hopkins standard of care. So because it didn't meet their idea of how to treat CRPS, their argument is that that justifies taking the child away. So what else? I think they're going to try to say that because their medical records said CRPS here and there early on and then down the road, that they were justified for billing $536,000 for a disease that they vigorously deny she ever had, and instead was always in her head. I think what they're going to say there is that, well, because some of the treatments we use can be used for CRPS, see, we could bill it. We have a memo, an internal memo that says that they actually made a conscious decision to up their billing rate to CRPS because it's so much higher. See, CRPS takes a lot of effort to treat. You need occupational therapy, you need warm water therapy, you need physical therapy.
If they can prove that, I think that's another problem for the defense, that they chose to bill for CRPS because the treatments were much more expensive and they were going to make more money out of it. And that was part of the reason they wanted Maya to stay in that hospital, was because they could bill a lot more for her treatment. And that's why they got very angry when Beata and Jack said they wanted to bring Maya to another hospital within 48 hours of her being in that hospital, and fought so hard to keep her there. In my opinion, that could be a problem if they try and bring that up.
Therapy, psychological therapy, got a lot of different things that go into it. And so it's very expensive. But if you just, evidence will show, warehousing a child while billing for CRPS, wow. And you'll hear from the actual experts about ketamine infusions, why it takes so many, and what you do to determine dosage. It's called titration. Maya had pre-existing treatment by a drug that broke down the ketamine. So for what us would feel like, you know, a Jimmy Buffett concert level of beers, to Maya would feel like 2 beers. And so that's kind of the relevance of, not a very good one, but the relevance of the ability of the steroids to break down the ketamine internally. Plus, you got to give more to kids than you do to adults. Plus, she was on this medication for about 14 months. And so there's tolerances. So the way the anesthesiologists do it, which is the way all anesthetic is done, is that you titrate up. You start on smaller doses virtually every time, and you increase until the patient has a therapeutic effect. You know, taking them out of pain is having the right effect on them. There is no evidence anywhere that Maya Kowalski was ever in any danger, Maya Kowalski ever suffered any negative effect whatsoever. The evidence will show it is all speculation on what could possibly happen. And I believe the defense will present themselves as the saviors of this family.
You got 15 minutes.
Fine.
Yeah.
15. Thank you. I may not even actually use it. So we'll lay it out. We'll bring in witnesses to tell you about CRPS. We'll tell you witnesses who spoke with Beata on her descent to the point where she felt the only way to get her child out of there, the maternal instinct was to kill herself. Take herself out of the picture, daughter released. We'll present the experts on psychiatry, on ketamine, on the use of it. We'll have the doctor flying up, the ketamine comes from Mexico. We will have psychiatrists who have studied this. We'll have the actual therapist at the time. You may actually hear from some of the doctors from the outpatient part of Johns Hopkins and some of the people that were there at the time who agreed to testify. So we'll do our very best, and we'll try to introduce video and audio and photographic evidence to document every single element of our case. So Nick sort of serves as my walking laptop computer, remind me of stuff when I forget it. There's much to tell you. Well, you've been pretty patient here listening to all of this. It's an emotional case. What we will do is try to bring you together. What you do with it is up to you. I will put on the best evidence we can. I'll have a chance to talk to you at the end. Okay? Thank you.
Okay, that's the end of his that is the end of his plaintiff's opening statement. I'm going to go to the chat because I have a lot of comments that I've already highlighted that I want to address. Just need to stop at the defense opening because we're going to go through that next. Okay. Thank you, Robbie, so much for the super chat. Mel, and you guys rock. Thank you. Matt Bond says, thank you, Matt, for the super chat. Thanks for covering this. I have CRPS and I've gone through what Maya went through for 16 years. It is literal torture what doctors do to us. I am so sorry for that. Sarah Adams is also in the chat. She also suffers with CRPS. So when you see their comments in the chat, know that they are both suffering with this disease, and any information they are putting in the chat is from their own personal experience with this disease. Let's go to some of the questions and comments. Becky says it's damning that they said they were making it up, but then they charge insurance for that disease. Yes, if you're sitting on the jury, how do you feel about that? Iris, glad to see Maya's doing better these days and pray she continues to strive. The family has endured so much. Yes. Sarah at one point said that is not part of a neurological exam. And I don't know which part you're referring to, but I'm sure it is something that was causing pain to Maya. Ms. Leah, the good Dr. Kirkpatrick is one I looked at for pain management here in Tampa. Didn't take your insurance. I liked him a lot in the documentary. Yeah, and it's important to note they tried a lot of less invasive, less potent therapies for her before they resorted to ketamine. D, the attorney has had years to put this case into a riveting story form for the jury. So why start with the facts instead of the horrific, compelling story? Yeah, that's a matter of personal style and personal preference. And I tend to agree with you there. Understand somebody said you got to speed this up or it's going to put you to sleep. That was on 1.5 times speed. So imagine, what it was like sitting in the, if you're a juror listening to this. It's my style to keep the jury engaged and to keep it short and sweet, with putting as much information in there to keep them riveted so they want to keep listening. Otherwise, they start thinking about when lunch is and I'm hungry and oh my God, this is so boring. And it can get into a lot. Let me know if you thought that was too much information. It was a lot of technical stuff. I think it could have been made into a compelling story and just, quickly, this is what we're going to show. This is what we're going to show. And then in your closing, you can wrap all of that up and tie it up in a bow for them. But that's just my own personal style. Rachella, I watched the documentary last night and it was an eye-opener. Yes, it definitely was. Team Brittany, just the pain in her face right there speaks volumes. Yeah, and I don't agree with them zooming in on her. I think that's in poor taste. I hope you agree with me on that. Does it make for more compelling television? Probably, but breaks my heart as a mother. D, I would have started with all the love and devotion the family showed to their daughter before the hospital stay. Good point. Sim, they were intimidated because of Beata's intelligence and fierce advocacy for her child. That could be. Terry, the mother was made to undergo a mental health evaluation. Yes, she was. Matt, who suffers with CRPS, says one of the biggest triggers of CRPS flare-ups is stress. Yes, so being apart from her family while she's in the PICU at Johns Hopkins for 90 days probably did not help her symptoms at all. And in fact, we see that it did make her symptoms a lot worse. Ashley, yes, it's frustrating because they're ruining everyone's chance for cameras in trial. They have been told over and over again, it's not that hard, court TV. Aurora Knight. Many legalized medical kidnappings because medical professionals and social workers overreach and overact and don't want to search further or to believe must blame others. Yes, and another issue here or fact that I want to bring up to you is that in this part of Florida, this happened in Pinellas County, Florida. Not CRPS, the DCF, which is what we call CPS here in New York, is privatized. It's not government run, it is privatized. And I have some other clips from investigative journalists that have shown that because it's a for-profit business, the children in Pinellas County are 2.5 more times likely to be taken away from their parents. That's frightening. It's a frightening statistic. Matt says, Sarah, I take it minute by minute. It can flare that fast. Terry also suffers from some kind of nerve pain. I don't know if it's CRPS. I take at least 28 tablets a day, opioids, and that still doesn't control the nerve pain. Matt says another name for CRPS is phantom limb syndrome. It's where the brain tells the nerve receptors you have the worst pain possible after the injury has healed. That's terrible. Jennifer Bosser. Yeah, that billing is a huge problem for them. It's either fraud or it's not. And either way, not good for their arguments. I agree. Tim, how nice of them to treat a 9/11 firefighter and his family like this. Before they made their evaluation, I don't even think they got time to know the family at all. They didn't even have the time to review their own medical records before jumping to these conclusions and putting it into the system. So you're going to see also that initially their first call to the child abuse hotline, initially within 24 hours, DCF verified the CRPS diagnosis with Dr. Kirkpatrick and closed the file. But then within 2 more days, Dr. Sally Smith, who is the outside child abuse investigator for the privatized system, called the abuse hotline again to report it again and said that the mom had Munchausen by proxy. Sarah says, no short answer, pain signals, constantly misfiring, pain signals all over the body, swollen legs and feet, different body parts are all different temperatures. And that was in response to Ashley's question about, it's nerve pain. Sarah, again, who has CRPS, every day that she laid in bed, she would be getting worse in the hospital. Plus she was 10. Who doesn't want their mom? Yep. Iris says, Maya's mom was a registered nurse, but was she qualified to administer ketamine to her daughter? Yes, she was an infusion nurse, actually. She was a home duty nurse who actually, her specialty was going to people's homes and conducting infusion therapy. That was her specialty. Sarah says, it's long-term, progressive, and lifelong. And Matt says, we get to know it so well, we can tell you when flare-ups are coming like clockwork. Miss Donna Marie, queen of the mods. I am loving this community. You are also kind and compassionate to each other. I love that too. Robbie from Australia says a 10-year-old from Australia named Bella Macy is battling through CRPS, also labeled the most painful condition known to mankind. Sylvia, I have MS and Graves' disease. I could write a book about medical mistakes and diagnosis that took 30 years, and with me and many others. Mary says, thank you for covering this. Thank you for watching. This is not a story in my opinion, that's getting enough attention. This is not a trial that many people are covering. So I'm glad that you're interested in it. I'm interested in it. And I think that this is going to be eye-opening for a lot of people about how easily your parental rights can be taken away with regard to the medical decisions of your child. And it's frightening. Dog Oshi, and the hospital, besides torturing Maya emotionally and physically, torturing Beata emotionally and murdering her, pushing her to suicide, the hospital committed massive fraud by stealing over $500,000. Thank you, Matt, for your $5 super chat. Can we create a group for us in here with CRPS to share our journey with people who want to learn and support each other? Sure. Sure. That would be a great idea. Support groups are always a great thing. And Team Brittany, today's stream is yet another reminder to be kind to people. You never know what they are dealing with privately. Okay. So we've heard one side of this. Now we are going to listen to the defense's opening statement. This is the doctor for the hospital. Remember that Johns Hopkins Children's Medical Hospital is the only defendant left in this case. The other defendants have either been settled with or let out of the case. So let's speed him up also to 1.5. You can tell me if it's too fast for you, but I think it's about an hour long. So in order for us to get through this in a decent period of time, we're going to have to speed it up. All right. Everybody ready? If you are just tuning in, this is the defense opening statement in the court case of Kowalski versus Johns Hopkins Medical Center. This is taking place in Sarasota County, Florida. This is the case that was brought attention to in the Netflix documentary Take Care of Maya, which was premiered at it premiered at the Tribeca Film Festival in June, was quickly scooped up by Netflix and premiered on Netflix end of June, I believe, in of this year of 2023. The trial has just started last week. We are catching up with opening statements so that we can then start to cover the trial live and the testimony live for anyone who is interested in following this with me, as I am a recovering attorney with 30 years experience in this exact type of trial law. And here we go.
Good morning, almost afternoon. My name is Howard Hunter, and I have the privilege of representing Johns Hopkins Children's Hospital and the people who staff it and who make it. We're here today to defend this case. We appreciate the time and energy that you've put into this effort thus far. You're the most important people here. And we appreciate your attention. We appreciate your commitment both to the trial process and to the process of waiting until you've heard all the evidence before you make a decision or begin to formulate a decision. With me today, first of all, let me introduce my team. With me today are my co-counsels, Pat Crowell.
Sarah said privilege of representing the hospital. I agree with you. I think that was not a good way to start. I think that they've already been sort of painted in a poor light. And I think by him saying I have the privilege of representing the hospital might not have sat well with me if I was sitting on the jury. But yeah, thanks for pointing that out, Sarah. But again, you can see how his opening initially starts differently. He's introducing himself. He's introducing his co-counsel. He's introducing the other people that are sitting there in case they're wondering, like, why do they have so many people sitting at the defense table? I think they have 6 attorneys sitting there and some doctors that are going to rotate in and out coming to watch the trial. So, big team versus smaller team. But again, at least he's introducing himself and saying hello to the jury, which I think is important.
Wells, Ethan Shapiro, David Hughes. We also have today a representative from Johns Hopkins Children's Hospital, Dr. Anthony Napolitano. See it over there. Dr. Napolitano may or may not wind up seeing you as a witness as well. You'll see doctors rotating as corporate representatives during the trial. They've asked to do that for the purpose of being part of the effort to defend the hospital in this matter. The hospital, after all, is not just a big pile of bricks and mortar. It's the doctors and nurses and people and professionals who run it. And so we're here representing them, although I'll be referring to the institution generally, for brevity's sake, as either ACH or All Children's Hospital. I mean, you may hear Johns Hopkins occasionally, but I've been representing them for a long time, long before they were Johns Hopkins. This is a case that has a number of different facets to it, and the circumstances and facts that I'm about to discuss with you constitute our view of the evidence. You just heard Mr. Anderson tell you their view. I'm about to tell you ours. Judge has told you, and it's absolutely correct, that what you hear from me is not evidence. It's my view of what.
His subtitles were wrong there. It said what the judge told you is absolutely corrupt. That's not what he said. What the judge told you is absolutely correct. I don't want you to mistake what he said because of poor subtitling.
The evidence will show. This case involves a number of different facts that occurred over about 18 to 24 months. I can't cover all the details in 90 minutes. And if I did, both you and I would have our heads swimming from the effort. So I'm going to go over some high points. I'm going to discuss some matters that Mr. Anderson touched upon. And I'm going to ask your indulgence as we fill in the blanks over the next several weeks. This sequence of events began on October 7th, 2017. That's where the plaintiff's case against Johns Hopkins began. Before that, you're going to hear a good bit of evidence about what went before. You're going to hear about the development of Maya Kowalski's disease process. You're going to hear about where else she sought care. You're going to hear a lot about the details of that care and a lot about the problems with it. I'm going to cover some of those in just a moment. The point is, for now, that as of October 7th of 2016, Kowalski's had been to Johns Hopkins several times. They had entrusted Maya Kowalski's care to us on several different occasions. And in doing so, they had come up from their home in Venice, past Sarasota Memorial, a number of other hospitals, and sought out care from all children. Presumably, we vindicated their trust in doing that, and they came back to see us on October 7th. We had no reason to wish this family harm, and we still don't. Indeed, there's a tragic outcome in this case in terms of Mrs. Kowalski's suicide, and we regret very much that happened. The issue here, however, is who's responsible for that. And we're going to go over the facts of that and what the facts don't show in terms of any connection between what was done by All Children's and that tragic result. Now, as of October 7th, we had the Kowalskis seeking out care at All Children's, as I've said. We believe the evidence is going to show you that care was reasonable and necessary and appropriate. And indeed, we're going to suggest to you the evidence I'm about to discuss with you will show that what went before, the treatment that went before, did not necessarily fall into that category, any of those three categories. And that is the reason, one of the big reasons that we're here today. Now, as of this date.
And that's going to be something for the jury to decide. That is the standard. Was the care and treatment that she was receiving reasonable, appropriate, and necessary? His argument's going to be that it's not, and it's going to be up to the jury to decide whether that ketamine therapy was reasonable, necessary, and appropriate based on the medical testimony and the medical evidence and what they are going to see about her condition and whether or not it improved with the ketamine therapy. Just because a therapy is not legal in the United States doesn't mean that it's not effective. So although this coma procedure that she underwent and had to go to Mexico to have is not legal in the US, does not mean that ketamine therapy is not legal in the US. So you have to make that determination in your head. Ketamine is legal as a pain reliever in the US. It is legal. So please don't get confused about that.
As of the time that Maya Kowalski was discharged from All Children's, we believe that in fact, she had been set on a path of therapy that has enabled her to resume function, to get out of a wheelchair, to be relatively pain-free, and to be in a situation of participating in her school and in society as she does today. So how did we get there? Well, on October 7th, Maya Kowalski was brought to the emergency room at All Children's. As you've heard, she had bad stomach pain. She was screaming, crying, thrashing around, cursing at staff, very upset, and presenting a very challenging situation for the staff. She had pain in all her extremities. She had her whole body being said to be hypersensitive to any kind of touch. She was unable to walk. She had legs atrophied from disuse, from being in a wheelchair for months at that point, or maybe over a year. She had dystonia, alleged dystonia, different position of her feet, as you've heard, and she was demanding pain medication in large quantities.
I mean, that already made me mad when he said she had alleged dystonia. Alleged dystonia. Her feet were turned in. You saw the pictures. You saw the pictures of her in the wheelchair. Based on your common sense and your experience, do you think that she was faking it? Her alleged dystonia? As a juror, I'm sitting there and I'm like, that makes me mad hearing him say that. But, that's just me. That's my opinion.
Mrs. Kowalski arrived a while later, and you're going to hear that when she arrived, she forbade the doctors and the nurses to touch her. The doctors and the nurses wanted to assess her, to examine her, to put on a blood pressure cuff, to put on an O2 sat monitor, to take a temperature, and they wanted to find out why there was all this horrible stomach pain. Was it appendicitis? Was it a torsion of the intestines? Was there something badly wrong that an ultrasound or a flat plate of the abdomen or a CT scan could detect? Those questions were being asked. Mrs. Kowalski insisted that before there be any workup of the child, she wanted ketamine. Now, not just any amount of ketamine. You're going to hear a lot about ketamine in this trial. Ketamine is indeed an old drug, and it's a drug that is approved by the FDA for use as an anesthetic. It is not approved for use in children, nor is it approved for use in high doses as treatment for CRPS or chronic pain. That's one of the issues here. It's not just ketamine itself, but how it was used and the quantity in which it was used. Because ketamine is an anesthetic. It is an hallucinogen. It can create dependency. It can cause depression of vital signs. If not properly monitored, it can cause serious injury, life-endangering consequences.
And it can also alleviate pain. He doesn't say that.
Mrs. Kowalski on this day was challenging the staff to give her daughter a dose of 1,500 milligrams of ketamine. That is a big dose. That dose you're going to hear is several times, many times, the maximum dose that policies at all children's approve. You're going to hear experts tell you that is many times any kind of safe dose. And you're going to hear the ER doctor who was on duty that day, Dr. Layla Behar Posey, who you're here for by deposition because unfortunately she's no longer with us. And I mean that in this life. She'll appear by deposition. And in her deposition, you will hear her tell you what she did and why she did it. And you'll hear her tell you, most pertinently, that even if she was so inclined to give that much ketamine in the emergency room where she didn't have sufficient monitoring availability, she didn't have the capacity for long-term wake-up and intubation. For that period of time, she didn't have the facility she needed to do that. Even if she was inclined to give it, which she wasn't, she couldn't safely do it in that setting. Now, you're going to see that Dr. Behar Posey is not just a newbie out of medical school. You'll hear in her deposition what her qualifications are. You'll hear that she's board certified in pediatrics as well as emergency medicine. She's confronted a lot of patients, difficult patients in extreme pain. You're going to hear that this patient, as far as she was concerned, had some degree of uniqueness in that she'd never seen anything quite like this. And she'd never heard of these doses of ketamine. What she found out, ultimately, and what developed over the next few days, and actually the next few weeks, is that Maya Kowalski had been given thousands, tens of thousands of milligrams of ketamine over the preceding 9 months. Her doctor, Dr. Hannah, had given her the day before admission 1,250 milligrams of ketamine. And at that time, he's going to testify to you that he told the mother he was no longer comfortable giving that much ketamine, that it was too much for him to give in his outpatient clinic. And he actually sent her to all children's. You're going to hear that over the 9 months preceding this, that he had given her a gradually increasing doses of ketamine, 12, 15, over 20 milligrams per kilogram per hour, which is dozens of times the safe and effective dose that was approved by the hospital and that is talked about by the FDA. And that it's never been written up in the literature. You'll hear Dr. Hannah say, either by deposition or by admission on that witness stand, that this was at or near the highest per capita dosage he had ever given any patient. It wasn't working. So what happened was that he had maxed out with this ketamine dosage. He had sent her to all children's. And Mrs. Kowalski, despite what he had told her, despite what had happened over the last 9 months, was demanding even more. Dr. Posey heard this story from the mother. She heard how much ketamine the mother said Dr. Hannah was giving. She heard what the mother was demanding. She saw what was going on with this child. She'll tell you what her suspicions were about the child's condition and what was actually causing it. She called Dr. Hannah's office herself. Now, she learned that he gave 1,250 milligrams. She learned what else had happened the day before. And so she decided that she would attempt to stabilize the child. She literally she'll tell you about literally negotiating with the mother to give a small dose of ketamine and some sedative, to conduct an examination, to admit the child to the pediatric intensive care unit. You'll hear it called the PICU. And the idea that she had at that time was, let's get her in the PICU, let's get her evaluated by pain management, let's see what's really going on here, let's get her stabilized, and then let's see if we can wean her down off all this medication she's been given. So she admitted her to the PICU. And Maya Kowalski was taken up to the PICU floor, and that process, in fact, began after consultations were placed by the PICU staff to have her see anesthesiology, pain management, and psychiatry, as well as to do some more diagnostic studies and blood work. So what was being done here at this point? What was reasonably prudent with what these physicians knew and what they knew it? What was happening was that they had a child being given levels of medication that they had never heard of before, that the literature did not support, that the literature didn't even mention. And so they put her in a safe environment. They attempted to get her stabilized. They called the correct consultations, and they tried to investigate what was going on. We will suggest to you, the evidence will suggest, and the experts will say that that was a perfectly reasonable thing to do. There's no conspiracy here. It was an effort to safeguard this child and to see that she got appropriate therapy going forward, whatever that happened to be. Now, you'll hear that the admission diagnosis that was recognized at that time by Dr. Behar Posey and ultimately by Dr. Teppa Sanchez was CRPS, chronic regional pain syndrome. There were other suspicions, and you'll hear about those too. But for now, I want you to focus on what CRPS allegedly has as its features, according to Dr. Kirkpatrick and what you just heard from Mr. Anderson. It's lifelong. It's incurable. It can wax and wane.
What CRPS allegedly has as its features. Sarah, Matt, allegedly. Okay, so this is a hospital. These are doctors, and they're not going to agree on how CRPS presents. I don't like that, hearing that.
It can return at any time for any reason or no reason at all. It can cause a whole host of symptoms. And according to Dr. Kirkpatrick, who's the one who diagnosed it to begin with, it's incurable. It's always going to recur. It always requires ketamine. Now, if there's any suggestion made that Dr. Kirkpatrick wanted to try alternative therapy first and had some regard for what the previous doctors had done, we're going to invite you to listen to the evidence about that and to look at the evidence about that, see how much was done, how much was actually attempted. We believe the evidence is going to be that that wasn't something that was given a really fair, appropriate trial before ketamine was used. You're going to see, ultimately, Dr. Kirkpatrick, when this child was in the hospital in October and November of 2016, told Mrs. Kowalski that unless Maya Kowalski got more of his ketamine treatments, more of these high doses, she would die a slow and painful death. Well, thankfully, he was wrong. It has been wrong so far. And we think he will continue to be wrong. At this point, it's well to walk the clock back a little bit. I want to ask you to look at the evidence as you receive it on a comparative basis with these ideas in mind. You're going to hear, and you heard already, some recording from Dr. Kirkpatrick's first visit with Maya Kowalski and her family in September 23rd to be exact, of 2015. I want to focus for a minute on her condition at that time, what the evidence will show that. She was wheelchair bound. Her legs had atrophied. You saw the picture that Mr. Anderson showed you. Her legs and arms were hypersensitive to touch. She had limited use of most of her arms due to pain. You're going to see more of that. You're going to hear about pain in other parts of her body, alleged dystonia. She wasn't in school. She wasn't functional. She couldn't walk. She couldn't do her own ADLs. She had no normal function at that time. You're going to hear evidence that she came to that point from several admissions, primarily for asthma at all children, but they also concerned a number of admissions at other institutions. Now, Mr. Anderson has mentioned to you what the evidence is going to show about Lurie Children's Hospital, where she was taken by Mr. and Mrs. Kowalski. Tampa General Hospital, Sarasota Memorial Hospital. She had been seen as an outpatient by the first physicians group here in Sarasota, the Sarasota Memorial Group. She had seen some physicians from Lee County. There was over 40 specialists that she had seen before she found her way to Dr. Kirkpatrick's office. And all of those specialists, many of those specialists that weren't concerned primarily with asthma, felt that in her presentation, some of them were seeing her for asthma, felt that in her presentation, there was some psychogenic component of some sort. And there were words like conversion disorder, psychological component. There was even one at that early point who was concerned about Munchausen by proxy.
1 out of 40. 1 out of 40 specialists mentioned in his records that she may have Munchausen. That's not a very good percentage. And the fact that the mom, Beata, took her to 40 different specialists to try and find answers for her child, to me, shows that she's a caring mother. That some of these doctors may have thought there was a psychogenic component to this just means that they thought that maybe there was something psychological that was increasing her pain. And anybody who has this CRPS knows that stress can make it worse, right? Or can make it flare up. Oh, thank you, Duty Ron. Thank you, Duty Ron, for the super chat. How are you? Thank you for your fantastic coverage on all the cases you cover, compassionate and professional. Oh, I appreciate you. Thank you so much. Very sweet. Yes, Sarah, they accused her of doctor shopping, and we're going to your quote, yes, by seeing 40 specialists, she's doctor shopping, or she's trying to find out what's wrong with her daughter. If there's any parents on the jury, they're going to have a hard time getting them to swallow this theory. So keep that in mind with your own personal experiences. And we're going to talk about this after. Hopefully we can get through this relatively quickly. It is on 1.5 speed. If you want me to speed it up more, let me know, because we have the closed captions.
What I'm suggesting to you is all Children's didn't blaze this trail. We just walked it. We found it on our own, but we walked it. So did these other folks, all 40 of them. And actually, the number's about 48. The point is that was not an unreasonable thing for Johns Hopkins to ultimately come around to believing and come around to suspecting, because many others had suspected the same thing. The recommendations for treatment of this disease, or the diseases that were suspected before Dr. Kirkpatrick, were physical therapy, psychological and cognitive behavioral therapy, sustained, long-term, intensive. That was back then. That's pretty much the therapy that Dr. Kirkpatrick rejected, because he began the course of ketamine. When Dr. Kirkpatrick saw her on September 23rd, you'll hear him say, I believe, he didn't care what the other doctors said. He didn't care what the records showed. He didn't review the records. He never contacted him. He never talked to him. There was no discussion in which he said, gee, I think it's this. I'm a specialist in this. You're a specialist in pediatrics. Let's reconcile our differences of opinion. Didn't do that. Instead, he diagnosed chronic regional pain syndrome. He's the first one to do it. And he began therapy, ketamine therapy. Now, you heard counsel talk about what the evidence is going to show.
He's the first one to do it. Okay, so he's the first one to do it out of 40 doctors. Doesn't mean he's wrong. As we've heard from 2 people in the chat who suffer with CRPS, it took a long time to get diagnosed.
Dr. Kirkpatrick did. Dr. Kirkpatrick will say in this courtroom or by deposition 1 that he began this child on a 4-day treatment of high dose ketamine, what he considered to be high dose. You're going to hear incidentally that Dr. Hannah's high doses were multiple times what she was given by Dr. Kirkpatrick. He gave her 4 consecutive days of ketamine, and his records say that there was minimal effect. Minimal effect. He used opioids and narcotics to try to control her pain after those treatments. And we believe the evidence will show that as a result of those things, she wound up at All Children's Hospital with stomach pain and horrendous constipation. That was going to happen again and again, following large doses of ketamine and other drugs. She was being harmed by these things. But in September and then in October, when Dr. Kirkpatrick treated her with high-dose ketamine, he prescribed more yet. And so she went to Mexico to see Dr. Cantu. I'm glad to hear Dr. Cantu is going to be here. Dr. Cantu, in his deposition, described to us what his regimen of ketamine consisted of down in Monterey. It's a treatment that is not approved in this country. He developed it from a trial in Germany. I'll tell you that. It contemplates giving the patient 7 to up to 9 milligrams per kilogram per hour for several days and keeping them in a coma with intubation for that period of time. He's going to tell you that it's a risky procedure. He's going to tell you that he tells his patients that there is a 50% risk of death from that procedure. Now, he's going to say he's never lost anybody, but listen to the cross-examination of Dr. Cantu about the dangers of that treatment, the degree of ketamine that was used, how it was used, and what his expectations of success were, because those expectations were not realized. And that's a key factor, because what is going to happen here is that this child was given the same thing over and over and over and over again in increasing quantities, and it didn't work. And the first thing that didn't ultimately work was Dr. Cantu's treatment. She had to go back down to Mexico for a ketamine booster. Dr. Cantu will tell you that's fairly usual, that happens, and that then he expects them to be pain-free for a number of weeks or months. Listen to what Dr. Cantu tells you about whether he knew anything about what happened after this. Because what happened after this was Maya Kowalski was taken back to this country. She was taken to see Dr. Hannah. Dr. Hannah embarked on a course of ketamine treatment beginning in January of 2016 and extending to the door of all children on October 7th, 2016. 9 months of therapy, 55 treatments, an average of 1 a week or more. 55 treatments of ketamine, multiple times in excess, not just of what the doses recommended by the manufacturers were, not just in excess of those, not just in excess of Johns Hopkins all children's policy, multiple times in excess of what Dr. Kirkpatrick gave, multiple times in excess of what Dr. Cantu gave. You may even hear Dr. Cantu admit that he wouldn't give those doses in the circumstances that Dr. Hannah did. You may hear him say that he never gave them, period. But all those doses of ketamine and all that therapy and all those drugs over that 9 months, over that 13 months, we're going to ask you to look at the evidence and look at what the evidence shows about the result. The evidence shows that as of this October 7th, 2016, once again, Maya Kowalski is wheelchair bound. She's hypersensitive. She's unable to use her arms and legs. She's got chronic extreme complaints of pain. She's got leg atrophy and said to have this done. And in that year, incidentally, she gained 4 pounds. Think about that. You're going to hear more about that because Dr. Hannah will tell you that he recognized that his patient was malnourished. Over that period of time, over a year, she gained 4 pounds. Now, she also, at all children's, was on 21 different medications as of October 7th, 2016. 21 different medications. Let's compare for a moment what the evidence shows regarding Maya Kowalski's condition at the time of her first appointment with Dr. Kirkpatrick and the time she's admitted to all children's a year later. You can see the slide. The evidence will show that she was in essentially the same condition with one addition. In addition to the problem she was having when she saw Dr. Kirkpatrick back in September 2015, in addition, she was malnourished. You'll also hear evidence that during that same period of time, there were 3 occasions, October 7th was the 4th, when she was in the emergency room complaining of extreme stomach pain following doses, high doses of ketamine and other drugs. We suggest to you the evidence will show that she was being harmed by these large doses of medication. The evidence will show you that the doctor's concern about how much she was being given and the frequency with which she was being given it was very well placed and is vindicated by what happened later. Let's take that comparison one step further. We believe the evidence is going to show you that between the time that Maya Kowalski was seen on October 7th in the ACH emergency room and the time she was discharged 3 months later, she had gained 4.5 pounds, which is more than she had gained in net weight gain in the last year before admission. She was still in a wheelchair, but she wasn't complaining of extreme pain constantly. She was comfortable. She was using her arms, and we believe she was improved. There will be evidence you hear from the witness stand about her condition at the time of discharge versus her condition at the time of admission. But perhaps more telling is the condition under which she was discharged. At that time, she went from 21 medications down to 3. And at that time, she began a course of physical therapy and counseling that, by the following school year, had her back in school. That was pretty much the regimen that was recommended for her at all children's. that was pretty much the regimen that could have been given her earlier and sustained, and perhaps saved her a lot of anguish and pain, and perhaps this lawsuit. She got her physical therapy. She got counseling. Pain medications were withdrawn. You may very well hear that to this day she's on no pain medication. Now, you heard it suggested by counsel that she couldn't take ketamine. Indeed, when she was discharged, the court of this circuit, not this judge.
Objection.
Basis. What's the legal basis?
Motion eliminate.
I don't recall that one. Continue.
Directed her discharge. She could not be discharged without an order of the court. And she was discharged with instructions as to what medication she could have at that time. She could not have ketamine. She could not have heavy analgesics without the court's intervention. That matter was dismissed several months later after she did well in her father's custody. And she's free to get whatever she wants today. But for the present, let me just mention this. I'll deal more with it. You're going to hear a lot more about it. Once the court entered an order following a report of child abuse that she was to be sheltered at All Children's under the custody of the Department of Children and Families, All Children's Hospital did not have the ability to discharge her without court approval, even if it wanted to. You're going to hear evidence. You're going to hear evidence from DCF personnel who will tell you we're the ones that set the visitation parameters. We're the ones that decreed who she could see, when she could see them, what she could have in her room, what she would have access to. The hospital, unfortunately, was put in the position of having to implement those orders. That's what we tried to do. But throughout this case, we're going to ask you to try to avoid conflating what was done by the court or ordered by the court with what was done by the hospital, because the hospital is not the court. The hospital is not DCF. The hospital has to follow that, and the hospital doesn't institute that. The court and DCF do. Now, I digress a little bit there, but I want you to pay attention, I'm sure you will, to what the evidence will show regarding Maya Kowalski's condition today. She's not the head of her class at Venice High School. She's real close. She served in her student government. She works out. She's on track to get a high school diploma and an AA degree on time. She's dating. She's functional. She walks unassisted. She's not taking pain medication. To some apparent, she's doing very well, and we hope it stays that way. Now let's walk back the clock one.
That's an attempt to minimize her damages. That's an attempt to say you shouldn't award her any money because she's dating and she's going to school. I think that was in poor taste. That's just my opinion.
Once again, to October 7th, 2017.
Because guess what? She still doesn't have her mother.
At that time, we described somewhat what happened in the emergency room. You're going to hear more about that from nurse witnesses. Maya Kowalski was admitted to the PICU. We talked about that. Dr. Beatrice Tepa Sanchez was the one on duty that night. You'll see what her credentials were. She'll tell you what her credentials are and her board certification in pediatrics and intensive medicine. She will tell you that what she did was attempt to understand what was going on with this child. And you'll see her, and you'll hear her walk through her admission history and physical, and the research that she did into the records that were available to her at All Children's of previous encounters. You'll see her discharge summary, and you'll see the care that she took to track down what this patient's history was. And you'll see that when she did that, and she was able to get the child admitted and sedated and started stabilizing, that she did call appropriate consultations. She did get pain management and anesthesiology involved. She did call psychiatry. And because of her concern, you'll hear that she also called a pediatric child abuse expert, Dr. Sally Smith. You'll hear Dr.
Whoever watched the documentary knows who Dr. Sally Smith is, and I hope that either they call her to testify or they show portions of her videotaped deposition testimony, because in my opinion, she makes the most unsympathetic and she will turn witness that I've seen, and she will turn off the jury in a huge way. So we'll see if they show any portions of Dr. Smith's testimony or if she comes in. If anybody has any opinions on Dr. Smith's demeanor that they saw just clips of in the documentary, certainly let me know.
Smith is the head medical director of the Child Protection Team, CPT, for DCF, the Division of Family Services, or excuse me, the Division of Department of Children and Families. I just gave away my age, by the way. They used to call it the 70s. But in any event, you'll hear she contacted Dr. Smith to say, basically, I'm not sure what's going on here. Can you check this out? And you'll hear that Dr. Smith did. You'll hear that Dr. Smith was not an employee of All Children's Hospital. She was not part of the treatment team, but she was there as a resource. And you'll see over time, and we'll talk about this again in a minute, the investigation that she conducted in connection with her duties with DCF and the Child Protection Team. She was not an employee of All Children's and never held herself out as such. And you may hear from Mr. and Mrs. Kowalski themselves that they knew that from day one. Now, I mentioned that Dr. Step Sanchez got her colleagues involved. One of those colleagues you'll hear from is Dr. Richard Elliott. Dr. Elliott is a board certified anesthesiology in pediatrics. He will be here and testify about what he found, what his interactions with Mrs. Kowalski were, and how he believed this child needed to be weaned off of high dose medication and weaned off of the regimen that she had been on. You'll also hear from Dr. Jenny Dolan. She's in the same discipline. She too had interactions. And you'll hear from both those doctors that during the time they were caring for this patient, they were having a problem with what Mrs. Kowalski wanted. Mrs. Kowalski wanted an intrathecal pain pump placed in her daughter's spine to deliver a medication called clonidine, a powerful drug, into her spinal canal. She was told that was a bad idea by the doctors at All Children's. She was told the same thing by doctors at Nemours. Indeed, you're going to hear Dr. Kirkpatrick tell her that's a bad idea. She was insistent upon asking for that over and over. She was talking about taking her daughter back to Mexico and Italy for more high-dose ketamine that she had just come off of, and that the doctors at All Children's felt weren't working. And frankly, we would suggest the evidence suggests weren't working. The plan of care the doctors wanted to pursue was consultation, weaning of the medications, appropriate care, and ultimately transfer. Now, I'm going to go past the slide on Dr. Smith here and go fast forward here because I want to talk about several specific allegations that have to do with the sequence of events from this point forward in the case and what the evidence is going to show you about that sequence of events. This child was admitted with a consent form agreeing to treatment signed off by Mr. Kowalski on October 7th of 2016. By that Sunday, the family, particularly Mrs. Kowalski, wanted to leave. They were being dissuaded from that. They'll tell you that on the morning of October 10th or 11th, that they were told they couldn't leave. I'm going to invite you to listen to what the evidence will show about that encounter. We believe the evidence will show, and you'll hear Mr. Kowalski say that no one ever told him he could not leave All Children's Hospital. We believe the evidence will also show that at that time, with the threats being made by the mother to find more high-dose, dangerous ketamine, that it was reasonable and warranted for the doctors to decline that if they had chosen to do so. We don't believe they did. We think that the evidence is more persuasive and shows you that there was a convocation of folks on the morning of October 10th or 11th at which there was discussion of the plan, there was discussion of the weaning, there was discussion of stabilization. The plan being, let's get her weaned off this medication safely, and then let's transfer her to an institution where more intensive physical therapy, more intensive behavioral therapy, and more intensive occupational therapy is available. The evidence will show you that All Children's Hospital was not trying to imprison this young lady. We were trying to get her stabilized and transferred to somewhere where she could get the help that she needed. And you're going to see that that somewhere was identified by Dr. Michelle Smith and others as Nemours Children's Hospital. A brief look at Dr. Smith's qualifications. You're going to hear from her from the witness stand. Dr. Smith is presently our chief of staff. She's also a board certified pediatrician and intensivist. She came into this case on October 9th, and she virtually from the outset began discussing with Mrs. Kowalski transfer of the patient. Now, there's her plan of care. That's what she wanted to pursue. And she tried to get it done with a transfer from PICU to Nemours. She felt at the time that if she transferred the child to Nemours, the intensive pain management program could begin while the child was still an inpatient. Nemours declined the transfer. She didn't stop, though. Someone skip past this slide because we pretty much covered it. She didn't stop. After that discussion at which the family agreed to stay, and you're going to see multiple sources of documentation of that, after that discussion, she took it upon herself to call Nemours again. And she called a doctor named Lisgelia Santana Rojas. You're going to hear Dr. Santana Rojas, and you're going to hear from her, we believe, by Zoom. You're going to hear Dr. Santana Rojas verify what she was told, or what she told Mrs. Kowalski, and what Dr. Smith will say she told Mrs. Kowalski. And that's basically this. She said that Nemours wouldn't take a transfer for inpatient. but that Dr. Santana Rojas operated an outpatient pain management clinic, specializing in pediatrics because that's all Nemours does, just like all children. All we treat is pediatrics, all they treat is pediatrics. In their pain management program, they treat CRPS. You'll hear Dr. Santana Rojas describe that she told Mrs. Kowalski that. You'll hear her say that she was asked by Mrs. Kowalski, if I go over there, if I come to your program, will you put in an intrathecal pain pump? And Dr. Santana Rojas said, no, we won't do that. That's not part of our program. That's dangerous. It's against your daughter's interest. But what we will do, without ketamine, without analgesic, what we will do is give her intensive physical, occupational, and behavioral therapy. And I'm going to replicate with her the program I trained in at Boston Children's Hospital, Harvard Medical School. I've replicated that program here, and we're getting very good results. If you bring your daughter over here as an outpatient, we'll put her in our program. You hear Dr. Smith pretty much say the same thing. I'm not sure what Dr. Santana Rojas is going to say about this, but I know what Dr. Smith's going to say. And it's this. Dr. Smith left the hospital that day thinking she had a deal. She thought, okay, we're going to get this child weaned and stable, and then we're going to transfer her as an outpatient in her family's custody to Nemours pain management. Now, as you hear the evidence come in, you are going to see that at this point, on October 11th, 2016, there had been a report accepted to DCF. There had been an investigation started, but nothing really had taken place. There had not been a dependency petition filed. There had been no court order. The court hadn't denied Kowalski's access to her daughters. They hadn't done anything. At this point, October 11th, all Children's Hospital and its staff were attempting to facilitate Mr. and Mrs. Kowalski taking their daughter out of All Children's Hospital in their custody and taking her as an outpatient for treatment at Nemours. We suggest to you that if that had happened, we would not be together today. We're going to suggest to you that the evidence will show that if that had happened, it's reasonable to think that none of this would have occurred. We believe that had that occurred, this entire matter could have been sidetracked and never brought us together. But that's not what happened. Because the next morning, when Dr. Smith arrived back at the hospital, she found that Mrs. Kowalski wanted to take Maya Kowalski to Dr. Hannah for more ketamine, that she wanted to seek an intrathecal pain catheter elsewhere, that she wanted to obtain more ketamine elsewhere, and that there was still discussion of Mexico or Italy. Shortly after that, there was a shelter order. At that point, the circumstances under which Maya was a patient at All Children's were not dictated by the hospital, they were dictated by the court and DCF. Now, the situation proceeded with the weaning completed at All Children's. All Children's, the evidence will show, attempted to get this child the physical therapy on an inpatient basis that it could provide. We didn't think it was enough, but we did what we could. She got some behavioral therapy, although not the kind that she needed. We didn't have it available. That's why we wanted to transfer her. But you'll see as you go forward and you hear witness after witness and you look in the hospital chart, you're going to see that over and over and over again, we weren't warehousing this child voluntarily. You'll see it noted over and over. Medically cleared for discharge, awaiting.
We weren't warehousing this child voluntarily. Was she an Amazon product? We weren't warehousing this child. That turns me off. Let me know how you feel about it if you're sitting on the jury.
Court disposition. At the close of all the evidence, we'll tote up to you the number of times that appears in the record. But we're going to suggest to you the evidence is going to be conclusive that there was never any false imprisonment of this child at All Children's Hospital. Now, I want to talk, before I get into disease versus syndrome and problems with diagnosis, I want to talk about a couple other things. One is the matter of a battery and surveillance. We believe the evidence is going to show you that whenever there was a touching of Maya Kowalski, it was done for therapeutic or clinical reasons or to comfort a child. There was never any intent to do her any harm. There was never any intent to be offensive or harmful. And we believe that at the end of all the evidence, you're going to find that there was never any point at which a reasonable person would have taken offense at how she was touched and how her care was managed in that regard.
Again, that's going to be a question of fact for the jury, whether or not a reasonable person would take offense to the way that she was touched. if she was in extreme pain, that's a definite question of fact for a jury, and that's going to be their determination to make, not his.
Need to talk a minute about the problems with diagnosis here. You're going to hear a lot about CRPS, conversion disorder, and a number of other things. CRPS and conversion disorder and these mental diagnoses have a couple things that are significant about them. One is that they aren't diseases in the sense that doctors use that term concretely. A disease is something you can see and you can diagnose. There isn't any question about it. Appendicitis, most forms of cancer. There's the lab test that proves it or disproves it. If you have HIV, there's a lab test for it. If you have appendicitis, there's an imaging study that shows a hot appendix. Objective. Syndromes aren't like that. In a syndrome, you piece together a constellation of symptoms and a constellation of findings, and it's much more subjective. And that's why we have things like the Budapest criteria that counsel talked about. And you're going to hear a lot about that going forward. In this particular case, you're going to hear that there was a good deal of controversy about what this diagnosis was. When this patient came into All Children's, we did, in fact, admit her with a diagnosis of CRPS. And we continued to bill for that and to treat that. And we tried to transfer her with that diagnosis. But as time went on, for the same reason that CRPS was not suspected at Tampa General or at Lurie's or elsewhere, we questioned the diagnosis. And while the diagnosis was carried forward as a rule out, it was not the discharge diagnosis, although we noted in the discharge summary that it was never ruled out. Now, you're going to hear much about CRPS, but I'm going to skip past this slide because we kind of covered this. You are going to hear a lot about CRPS's rarity, and you're going to hear a lot of reasons given why we didn't believe this is CRPS. One reason was that it was presenting as a general pain syndrome involving the entire body. You know, what's the name of the syndrome? Chronic regional pain syndrome. Doesn't usually present as whole body. You're going to hear that's vanishingly rare, if not almost unheard of. You're also going to hear that there are various.
Wait, so first he's going to say that they've never heard of CRPS before, and now he's going to say that, oh, we knew what CRPS was, but here's what we say it is, and that's why. See, he's already confusing me, and I have a law degree. So imagine what the jury's head is spinning right now. He's getting way too much in the weeds with his medical jargon and lingo, and he should just leave it for the doctors to explain to them and say, the doctors are going to tell you this, and leave it at that. He's already in the weeds on this, and I don't know if he can dig himself out in the next 11 to 14 minutes.
Presentation factors about this disease that were never really observed on a consistent basis, like decrease of hair loss, nail changes, skin asymmetric tissue changes in the skin. A lot of these observations about CRPS just weren't consistently present. There were, however, reasons to suspect conversion disorder. Now we've arrived at psychiatric or psychological issues. There's a lot of misconceptions about psychology and psychiatry and mental illness. And people act like saying it's conversion disorder or it's all in your head is some kind of epithet. It's an insult. That's not the case. When these doctors are writing down conversion disorder, they weren't trying to insult somebody. They were trying to attach a suspicion and a diagnosis to get a patient the help they needed. No one's telling this patient she doesn't have pain. What they're saying is that what their question is what's causing it and what you do about it. And that's a central issue here in many respects, because this entire case revolves around not so much what the diagnosis is, but what the clinical treatment is. I've got a slide here in a minute that will show you this, but I'll probably skip and get to it without getting it out of order, because as usual in an opening statement, I'm way off the reservation from what I'm supposed to be doing in order. But since it's appropriate, I'll say it here. When you look and when you hear what the evidence is about the reasonable standard of care treatment for CRPS, for conversion disorder, for a pain syndrome manifesting as Munchausen by proxy, for factitious disorder manifesting as a pain syndrome, when you hear what the treatment is, the clinical treatment is for all those things, same thing. Maybe the mix differs, but it's basically physical therapy, occupational therapy, and psychological or cognitive behavioral therapy. Those are the treatments. And you're going to hear from experts who treat this disease day in, day out, and these diseases, I should say, all of them, day in, day out, and they do it without putting the patient in a coma, without giving the patient 15, 20 times the recommended dose of ketamine over months and months and months. They do it by therapy, and the results they get are stellar. And you'll hear that from them. You'll also hear that for that same set of reasons, this business about billing just isn't supported by the evidence. You're going to see the billing records. You're going to see the billing sheets. You're going to see that CRPS was an item. It was one of a number of items that was being billed for. You're going to hear that there was no change in the medical reimbursement for the billing as a result of where, in what place, whether it's 1 or 12, and that's literally how many diagnoses there were that points in this, whether it was the first diagnosis or the 6th or the 8th or the 10th, you're going to hear that the billing reimbursement never changed. And the reason for that was that while you needed a diagnosis to put on that code, what was really being billed for was the services rendered. And you'll see the billing sheets and the services that are laid out item by item, and you'll see that those didn't change either. You'll also hear that none of this cost Mr. Kowalski a dime. And you'll also hear that the insurer who was billed for the services rendered by All Children's Hospital for 3 months of inpatient therapy, the insurer never complained. Didn't say a word. Approved the care, approved.
Okay. 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 All right. Oh, I have a lot to say about this. You're going to hear that Mr. Kowalski didn't pay a dime, that his insurance company paid the whole entire thing. Okay. That somehow makes it right that you're billing for the CRPS that you accused the mother of making up and accused the mother of Munchausen by proxy to the point where she offed herself. You're going to make the argument that the insurance company paid it. They didn't question it. They didn't care. They didn't care. They're an insurance company. Does anybody in the chat pay their own health insurance that's not covered by a job who pays your health insurance for you? Does anybody know how much it costs to pay for health insurance right now? And he's going to make this argument that they didn't care. They paid it. Doesn't matter. Our billing was sloppy. Okay, so what? Okay, because here, if your billing was sloppy, what does that say about your medical care? And that's what a jury's going to be thinking. In my opinion, this is a horrible thing to bring up right in your opening. Horrible, horrible, horrible. Mr. Kowalski didn't pay a dime. Wow. Wow, wow, wow. Not a good way to open.
The billing, no problem. Now, you're going to hear a lot about Munchausen by proxy, and I'm going to kind of fast forward through this for one reason, that we're running a little bit low on time. But the other reason is that it's a very technical thing, and it doesn't merit near the attention that it's gotten because it's a flashpoint throughout this. There was a suspicion of Munchausen by proxy. It wasn't just All Children's.
And now he's going to minimize. Now he's going to minimize their accusations of Munchausen by proxy. It's not a really big deal. It's not really a big deal here. It's not really, it's just a flash in the pan. Just a flash in the pan, he says. Keep this in mind if you're sitting on the jury. That the hospital's attorney is telling you that it's just a flash in the pan. Not really important here. We don't really need to talk about it.
Suspicion. There was a concern that part of this child's condition was being fostered or encouraged by the mother. There was a concern that the mother was seeking out care that was too aggressive, that was dangerous, and would persist in doing so if she were permitted to do so. That's what got this ball rolling. I told you a few minutes ago what the evidence will show about the attempt to transfer for outpatient care, why it failed, and why, as a result of that, these investigations rolled forward. This is a slide I told you I'm going to skip because it talks about what the therapy is and how it is all of them. We talked about billing fraud, so I'm going to skip over this slide as well. Let me talk about photographs.
Billing fraud. He, in his own opening, calls it fraud. He calls it fraud. He doesn't call it a billing mistake. He doesn't call it a billing error. He doesn't call it about a billing decision. He doesn't call it a billing code. He calls it, we already talked about billing fraud. Whose side is he on? Again, just my opinion. But it's putting that into the minds of the jury. Oh, wait a minute. He's talking about billing fraud and his client's the hospital?
Just for a minute. You've heard about the photos that were taken. These photos were taken for clinical reasons. We believe the evidence will show you that they were taken pursuant to the consent that Mr. Kowalski signed when he was admitted, and which he will, I believe, admit to you he never rescinded. The purpose of the photos was to document the condition of the child If there were skin lesions, even if they were not being documented in the nursing notes, they needed to be documented. They needed to be observed if they got worse. If there were new ones being developing, we need to know that too. But the point is that they were being taken to assist in diagnosis and follow the child's condition. You heard about surveillance, the movie, surveillance video. You're going to hear that wasn't a new idea either. That also happened at Cambridge General. Why was it done? Because medical professionals wanted to know what the child's capabilities were. Now, that video is going to tell you a couple, you're going to see, we're not going to ask you to watch 42 hours of video. You're going to see grabs from that video that show several things from our standpoint. You're going to hear some complaint blocks. From our standpoint, you're going to see in that video that Maya Kowalski, who's saying her legs are hypersensitive and can't be touched, saying she can't move her legs, is moving her legs in bed, moving her legs into a position that we used to call Indian style, and now we call crisscross applesauce. She was able to assume that position and hold that position voluntarily without a problem. You're also going to see and get some idea of the fact that she was not in that room for 42 hours. You'll see that she's in and out. She went to therapy. She went to other places. And you'll see the nurses coming and going and assisting her when indicated to the commode. The commode wasn't placed out of her reach for any kind of malicious purpose. It was placed in the position that it was because she had nursing staff available to help her, as you'll see they did. And because if you put it too close or in too close position to the bedside, it would obstruct the nurse's ability to get to the bed. It was strictly a matter of happenstance. It was not a matter of intent. And that brings me to another point, and it's on this slide. You're not going to hear any evidence that the 50 some odd medical doctors and professionals who took care of Maya Kowalski over 3 months somehow banded together in some sort of cabal and hatched a plot or a conspiracy to do harm. You're just not going to hear that. You're instead going to hear from a constellation of dedicated pediatricians and dedicated specialists who were genuinely trying to do the right thing for this patient. They may have differed in some opinions with the family, but their uppermost objective was to keep this child safe and to get this child the therapy and the treatment that she needed. Now, why was the diagnosis an issue if the treatment was the same? That's a reasonable question. Let me suggest to you the evidence is and will be that the importance of the diagnosis is the result of the fact that that CRPS diagnosis was being used to justify dangerous care, dangerous levels of ketamine and other drugs that aren't even recognized in the literature. Those doctors weren't going to come get the patient. The family's going to take the patient to those doctors. And so it was important to get the diagnosis straight and treatment straight so that the right mix of therapy could be formulated and the best job could be done to get Maya Kowalski into a position of being comfortable, functional, and lead a happy and healthy life. That's what we were attempting to do. There's never an intent to do anything but that. Over the next few weeks, we think you're going to hear a number of experts in the courtroom. We'll be bringing in experts from California and elsewhere. They're going to talk to you about whether or not the overarching allegation against all children's and its physicians, including even Sally Smith, that they were negligent in Maya Kowalski's care and that their negligence somehow caused injury. We're going to suggest to you that, first of all, there was no ultimate injury caused, given the condition that she was given to us in. But more importantly, there was no deviation from the standard of care. You're going to hear from different doctors in different specialties that the care that was taken in diagnosing and treating Maya Kowalski, you're going to hear about teams of consultants. You're going to hear about meticulous investigations. You can see that Sally Smith formulated a 45-page single-space report of her review of literally thousands of medical records to come up with her diagnosis. You're going to see a lot of effort and care and expertise went in to the effort made to treat this child at Johns Hopkins All Children's Hospital. We believe the evidence will be unequivocal. That degree of effort, insight, investigation, and monitoring and care comported in every respect with what is reasonable and what is recognized as being reasonable and appropriate by other similar physicians. And we don't believe you're going to hear any credible evidence otherwise. You heard the judge give you a definition of medical negligence. I just kind of paraphrased it. But the point I'm making to you is the evidence will ultimately show that these doctors and these nurses and this hospital staff acted reasonably and prudently to treat a difficult and challenging case they were presented with, and they did it consistently over 3 months. They don't have to be right under the law. All they have to be is reasonable. We will suggest to you the evidence will show that first, they probably were right. But even if they weren't, they were more than reasonable. At the end of all this, at the end of all the evidence, I'll have another chance to visit with you, or my colleague, Mr. Shapiro, would. You're going to hear a lot between now and then. And again, I appreciate very much your attentiveness and your diligence, as does my client and people at All Children's Hospital. I thank you for your attention and look forward to working with you the next few weeks. And you'll be pleased to know I skipped at least 3 slots.
I skipped at least 3 slots. I don't know what he's talking about. Oh, slides, maybe. Maybe he was saying he skipped at least 3 slides. Okay, so even though we had this on 1.5 times speed, it still took us, we're still into this right now for 2.5 hours. And we had a lot of really good comments, and I tried to put them up during the presentation. Something I just want to explain to you here, which is different than the way that we do things in New York. In New York, these types of cases are bifurcated, which means that there are 2 trials. The first trial is about fault. And so the jury hears all testimony on fault and nothing about the injuries, the damages. And so after that decision is made, if they find fault, then you go on to a second trial on damages and what money should be awarded and why. This case seems to be unified. So they're talking about fault and damages all in the same trial. It can confuse the jury. It can bring emotion into play. It can say, like, you know, we want to award them some money, so we're going to find fault. I think a bifurcated trial in these types of cases is a little bit more fair because they're not really hearing about the injuries. But, this is Florida, and I can't claim to know all of Florida's nuances and the law and their procedure. So it's a lot different than what we do here. And maybe they made a motion to unify it. I'm not really quite sure. The court file is voluminous, as I told you, thousands and thousands of pages. Oh, thanks, Lisa. I'd be so much better presenting this case. Thank you. Angie, you made it finally. Thank you for reviewing this case. Thank you guys for wanting to watch this case. Nobody seems to be covering it, and nobody's definitely covering it live. So we are playing catch up today. If you're just tuning in with the opening statements, the super long filing I mentioned yesterday available to non-lawyers. I'm so impatient for the actual evidence stuff. There's so much in the court file that you'll never be able to get through it. You can go onto the website for the Sarasota County Court, and you can access the court file and you can open up the documents individually. But I'm telling you right now, that's a rabbit hole that is going to make your head spin. There's so much there. Mary, yes, they could settle at any time during the trial if the defense wanted to and the plaintiff. They both have to agree on a settlement, but yeah, they could at some point. I don't know if there's been any offers on the case. All settlement discussions are confidential, so they can't even bring those up during the course of the trial, obviously, for obvious reasons. If they are in negotiations, the case could settle at any time and the trial would be over. So if that does happen, the trial will stop. Tracy, I wanted to put this, thank you for this, because I wanted to put it up for a second time. I thought it was so important. It's not like Beata was going to get ketamine on the dark web. She was wanting to take Maya to a doctor who understood Maya's experience with this condition better. What about their freedom of choice? And that is why I think this case is so important to cover. Because not only are we learning that a hospital can set the wheels in motion to take your parental rights away with regard to the care and treatment of your child, but they can also set in motion a process that will deprive you of your freedom of choice with regard to your child's medical treatment and take custody away from you. This child was put into state custody because of the wheels that the hospital put in motion and because of the opinion of this child abuse doctor expert, Dr. Sally Smith, who you're going to hear through testimony, came into the room when the parents were in the room with Maya, did not identify herself, did not say, I'm a child abuse doctor who's investigating this case, asked them questions for 10 minutes. And literally after DCS had already closed the case on this, because of Dr. Sally Smith, it was reopened, and that's when their parental rights were taken away. So we're going to hear more evidence on that, but that is what happened here. And that's why this is an important conversation for us to be having, because this is really, really scary. And most of the cases that we cover from the true crime side of this, we complain about DCF and CPS not doing enough and not taking children away when they should be taken away and not replying or responding fast enough to complaints. And because of that, the children often wind up unalived or in horrible conditions, or, in the case of Ruby Frankie's kids or Harmony Montgomery. And those are just two that I can think of at the top of my head. Yes, Peter. Yeah, majority rules on a civil case in Florida. There are only 6 jurors, and they do not have to be unanimous. They have to be a majority. Maybe 5 out of 6. I don't know. I'm not an expert on Florida law, but it does not have to be unanimous. What I would like to do is, since we are now caught up on opening statements and they are going to resume testimony tomorrow, which we can cover live if you are interested, and I know a lot of you are, is ironically, I have to take one of my own children to the doctor today because they are off from school. So I need to go do that. I would come back later if you guys want to and go over all of the testimony that has already been heard in this case. And it includes the teacher. It includes Kyle, Maya's brother. It includes the brother of Maya's dad who found Beata after she had taken her own life. So if you'd like to do that, put a Y in the chat and we can come back later tonight and do that. I will post it up when I have a time for that. So if you want to do that, I'm willing to. Please. Okay, we have some pleases. Yes, please. Yeah, I think it's important because if we're going to cover this case from start to finish, I think that we need to hear it all. And I think that we need to hear what the jury's going to hear, and we're going to put ourselves in the shoes of the jury. And if you didn't watch the documentary, there's some people who are saying, I don't want to watch the documentary, because everything pretty much that's in the documentary, I think, is going to make it into the trial. So there's no spoilers. You've already heard all the spoilers in the opening. And I don't think that it's going to prejudice you to watch the documentary. I thought the documentary was well done. I don't think it was, totally skewed from the point of view of the family. It's important to note, if you did watch that documentary, that the guy who made that documentary is a first-time filmmaker. And I thought that it was incredibly done and sensitively done, and is shining a light on something that we really need to talk about and that really needs to be brought into the public eye more. Thank you, Dee. Yes. Okay. All right. So I'm going to take my child to the doctor. Now I'm going to be very careful about what I say. But also, let's reconvene later. Think about the questions that you have. I'm going to see how long that testimony is going to be. I don't think it's going to be as long as the testimony that we watched today. I think Law and Crime, or maybe Court TV, has broken it up into pieces so we can watch it in pieces. And yes, we're going to cover this again, Maya, tonight with the testimony that's already happened. And then tomorrow we can start covering it live, because thank you, New Hampshire woman. Thank you so much for your super chat. I appreciate you. All right. So if there's any other super chats that are not here that I did not address yet, I do not see any. I will see you later. I'll post it up soon and we will reconvene and we will catch up with the testimony. And then tomorrow, I don't know what time yet, Tim. I'm going to have to, can you just tell me where most of you guys are listening from? Just put it quickly in the chat where you were listening from or watching from, so that I can get a better idea on time zones. I'm in Eastern time in New York. Scott, this is saying a lot for you. You kept my attention. It wasn't a criminal trial or Costner, right? Right. Okay, Ontario in the house. England, you guys are 6 hours ahead. So I don't know if you're a night owl like me, but I am a night owl. So I'm going to check with Duty Ron and see what his schedule is for tonight if he's going on, because we try not to conflict. Oregon Ducks. So you had to throw that in there, Sarah, huh? To just give me that little dig. My poor buffs. Okay, so it looks like there's a lot of people in the U.S. Who are either behind in time, Eastern, Mountain, Central, Texas. Okay, so if I do it I'm going to check. Let me check with Dude. Ron, are you still in the chat? If you're in the UK, it might be kind of late for you. All right. So I will decide on a time, maybe early evening here in New York, which would be earlier in the UK, and we'll behave. People are saying, great show and well behaved. Good. So the chat wasn't too hard for you today. So I know you weren't so excited about coming in so early in the morning, at 10 a.m. Okay. So let's reconvene later. I'll put the time up. It's probably going to be around 5, 6, 7, depending on what duty you're on. Oh, he's having a day off. I don't know. If he is, then that's cool. So let's, maybe we could do like 5 p.m. We'll conflict with the 5 o'clock news and we can watch me instead. So tentatively, let's think about 5 p.m. I will post it. So make sure that you have that bell set to all notifications. Make sure you subscribe. Make sure you like this video, share it out. It helps the algorithm. We need to get more people interested in this case because, in my opinion, Ruby Franke and Jody Hildebrand are getting way too much attention, and that case isn't even anywhere near trial. Okay, so that's my opinion, and I'm sticking to it. Thank you to all my moderators for keeping the chat classy. Thank you to everyone who participated in the chat. Thank you to my subscribers and to my replayed crew. And we will reconvene later. Make sure you have notifications set because you don't want to miss it. All right. Bye, everyone. Have a great day.